Adjournment request, if any, from item number 1 to 5. From item number 6 to 15, adjournment request.
May I please, Your Lordship? I like to mention item number 9, my lord. With the consent of the other side, my lord, I would like to mention that matter may be taken on 13, my lord.
That we can't ensure. You take time today, we give you date according to our calendar. As prayed for. On behalf, you are for the appellant,
My lord.
as prayed for on behalf of the appellant, 2 weeks.
22nd 8. From item number 16 to 23, adjournment request. Daily list for orders, item 1. Oh, sorry. Any other request?
Wait, Your Lordship. Lordship, in item number 19, Lordship, an affidavit in opposition was filed by the state of Assam on 2nd of August, Lordship. That is Saturday, Lordship. I pray that an affidavit in opposition filed by the state may be called for, Lordship.
Let's see, let it be called out.
Yes, Lordship.
You're not seeking any adjournment in the
Lordship,
matter.
I pray that an affidavit filed by us may be called for, Lordship.
It shall be there on the record, no? If it is not there, we'll, otherwise also we'll see. Let it be called out. Yes.
Daily list for orders, item 1.
May please, Your Lordship. Well, there is a delay of 245 days in preparing the review of the
Notices issued,
notice was issued, madam.
appearance of the other side.
I'm appearing on behalf of National Highway Authority of India, that is response number 2, 3, and 10.
How many respondents are there?
11. I am for 2,
11.
You appear for 2, 3, and 10.
my lord.
Others? How about
Accept it.
5 to 11 you appear. And most of the response say,
I am appearing for respondent number 1 and 4.
all taken. So we are condoning the delay. There's an application seeking condonation of delay of 245 days in preferring the review petition. We are satisfied with the reasons given in the petition that there was good ground. Satisfied that there are good grounds for condoning the delay. The delay is condoned, the application stands allowed, the review will be registered.
Hello, madam. Copy is issued to the board. If you have the video.
Take it. Yes.
Item number 2.
What is this? What is this?
Content. No, that's very serious. Content cannot yet comply.
Yes, who appears? Nobody appears on behalf of the parties, re-notify 2 weeks.
27 8. Item number 3.
Condemnation.
3, 4, 5, and 3.
Wait, please, my lordships.
May it please your lordship. Lordship,
Notices don't.
lordship, in this item from 3 to 7, learned advocate general will appear, lordship.
Is he opposing the,
He's in court
no,
number
no,
5.
would he be opposing the condonation application?
No, lordship, he's appearing for the state of Nagaland. We are from the
You are for the
appellants.
So.
I'm
you can-
for the respondent lordship. May it please, my lordships.
Yes,
I am for the respondents, private respondents.
all right.
Lordship, in this IA that they have filed, only in one IA they issued notice through newspaper publication, and only that I have seen the publication notice. Now, my lord, in this, I am sure they have filed for condonation of delay of 142 or 43 days, lordship.
Right.
Here, lordship will kindly appreciate that, my lord.
Would you
They
like to
have
contest?
approached even the Supreme Court. This appellants have approached the Supreme Court, and Supreme Court by order dated 21/1/2025 already rejected the SLP and dismissed the SLP, Lordship.
That's all right, but then there is a direction to then the SLP was rejected on the ground that they will go for review. Is that correct?
That has not been, Lordship, in the order, it's not
The
been
IAs
reflected.
All right, all right, we have heard you. All the IAs allow the application, delay condone. The registry to register the updates.
Lordship,
Yes,
my humble prayer before this honorable court is that till that we have not received any notice. So notice may be accepted, notice may be sent, and we will accept notice in all the 5 retailers.
only in one case, that's IA number so and so. Okay, all right, so we keep your IA intact, you receive notice. If you have to file any affidavit, you do file,
Yes, yes.
but it would otherwise unnecessarily delay. If you have come, if you're here, if you have got the notice through paper circulation, you can very well accept the notice. If you have to file an affidavit, all right. Do you intend to file an affidavit?
Exactly, Lordship. We need immediate disposal of this case, Lordship. And my Lord will kindly appreciate that, for 5 years, because of this case, no
That's true.
advertisement has
That's
been
not
made.
on the merits of the case. We will dispose of the petition. Maybe the appeal would not be allowed, but then you have to allow the court to hear the appeal, no?
Lordship,
Delay is not such that we would not condone it.
Lordship.
So are you ready that this delay be condoned? Then we go ahead. We will have a date fixed for appeal.
Lordship. Sure.
You don't want to file any affidavit in opposition, or you do?
Delay. We will file. In the IA.
All right. The rest other applications allow continue. Next.
Even she is appearing
Yes, sir.
to take.
She is an IA number?
This is IA number 2104.
2106.
No, 2106.
All right. Only this IA. Let notice only in this IA. Notice issued to so and so. She, advocate concerned, takes time for filing affidavit in opposition. Let that be done by the next date. Re-notified so and so. The rest other. Only after the condemnation of delay of this IA would the appeals be listed.
Lordship, because
Lordship.
We give you 2 weeks. Is that good enough?
Good enough, Lordship.
All right, 2 weeks. Yes.
In the meantime, Lordship, I have not received the copies of the IS as well as the writ appeal.
You're addressing this court from where?
Kohima bench, Lordship.
Kohima bench. Any local counsel available here?
Yes, Lordship. BM Chetri is there.
The
The
local
Bakalatnama.
handed over a copy of the brief.
We'll cover. Otherwise, we have sent also and we have given paper.
Doesn't
copy.
matter, just give her a
We'll
copy.
give one copy. Lordship.
It'll be served during the course of the day, don't worry.
Lordship. Obliged, Lordship.
On 28th.
Deeply obliged, Lordship.
All allowed except that.
Yes. Item number 8 for admission.
Fair Compensation Act. Some land requisition and acquisition.
What the?
Requisition and acquisition 1964.
Yes. Yes.
My lord. My lord, the petitioner is challenging the judgment and order passed by a single judge. But prior to that, my lord, I may just give a brief, my lord, in 4 lines only, my lord. In 2002, my lord, a 30 premises and 30
You're
bigas,
not very audible. If you could speak in the mic.
30 bigas or more, 59 bigas, my lord, were taken over by the battalion of the CRPF for immediate need of the law and order situation,
That's right.
which was handed over, my lord. Thereafter, at that time, company was the Woodcraft Limited. That company was sold to the present appellant company. And the position of the land is with the CRPF from since 2002. In the meantime, the another battalion came And they also took over. The third battalion came, they also took over. Neither the electricity charges nor the rent was paid to the petitioner. Now, under such circumstances, my lord, the petitioner approached this honorable court, and any single judge dismissed the writ application on the ground of delay. But thereafter, my lord, the writ appeal was preferred, and the writ appeal was disposed of with the direction to the deputy commissioner to assess the rent of the premises and to make payment of the same. Accordingly, my lord, the assessment was made by the deputy commissioner and was sent to the government for sanction. But government unilaterally, my lord, reduced the amount to 11,000 rupees per month for the 12,000 per month for the entire plot of land. And on that basis, my lord, we again approached this honorable court by a writ application. The writ application was again disposed of with the direction to the government to reassess the value of the rent, and if necessary, a committee to be constituted for the purpose of assessment of the rent. My lord, after the order was passed, again the government unilaterally fixed the same amount of 12,000, and the post facto hearing was granted. Petitioner filed a representation. The representation was not considered, and again the rent was fixed at 15,000 rupees. We again approached this honorable court by way of writ application, and that writ application was disposed of without interfering the rent which was fixed.
But all this has happened without looking at the provisions of the law. Now, Mr. Saraf, you tell me one thing. You purchased it from the Woodcrafts when?
My lord.
When was it purchased?
2002.
You purchased it in 2002.
My lord.
When was the CRPF battalion allowed?
Prior to that, by the.
Give us
earlier
the year.
government.
Give us the year.
My lord.
Which
My lord,
year?
2002 itself, my lord. Prior to some month, my lord.
Anyway, prior to your purchase.
My lord.
So you were aware of the battalion having occupation of the premises of
Absolutely.
entire 59 figures,
Absolutely.
right?
My lord.
And therefore, principle of caveat emptor would apply.
My lord.
Principle of caveat emptor.
My lord.
Now, therefore, what was the agreement with the Woodcraft of the CRPF battalion?
My lord, when the Woodcraft has given the premises to the CRPF, it was for the limited period for law and order situation, and it was said that whenever they will direct, they will vacate it.
That's right. So was there any agreement that electricity charges would be paid, rental would be paid?
My lord, there was annexed.
All these aspects have not been gone into in the division bench's judgment.
My lord, absolutely.
So therefore, how do we know? And you're challenging the very assessment and the powers of the state to reduce it unilaterally
My submission.
without any reason. Yes. No, we are with you.
My lord.
Your premises, you have spent money in purchasing a CRPF battalion successively has been occupying your place. You need to be paid. But for that, for a judicial order to be passed, we must know what was the agreement with the original lessor. I mean, I wouldn't say lessor, with the original landholder.
My lord. My lord, in fact, as such, I don't find any agreement. It was temporary arrangement by the event, but I don't find any admitted.
No, you'll have to tell us on affidavit what is the reason. We shall dispose of this appeal.
My lord, only thing. I'm sorry, my lord. I'm sorry.
We shall dispose of this appeal. We will, we will put a decent quietus to this. It doesn't look nice that every time you're asked to go and represent, and then in the meantime, what you do is that you give us the exact position.
Right.
What was the agreement? When did you invoke your rights as an owner, as a property owner?
My lord.
Then what happened? What was the basis? Is there a law for fair assessment of rent? All these things you will have to tell us. Otherwise, we don't see any such aspect having been dealt with in single judge's order. Or perhaps the division bench
I
of the.
agree, my lord, in none of the judgment, my lord.
So therefore, unless you explain it to us, we'll again remind you back.
But my lord.
That would not be proper.
My lord, only one line, my lord. My lord, the district council, my lord, determined the value and took the transfer charges, which itself amounted 29 lakhs, which was 5%. Now the valuation of land was also done by the district council, and it was done to be 5 crore something. 5 crore 98 lakhs. The valuation was done by the district council.
Mr. Saraf, valuation of land does not necessarily determine the rental. The land could be valuable, but commercial viability is the index on which the rental value is assessed. And you have a law in every state. I don't know about Assam. You will have to tell us how it is to be assessed. And there is a fair rent tribunal also. You have to tell me. So these aspects have not been gone into.
Well,
It's
my-
only a question of,
My
so when you purchased the land from Woodcraft, what was the agreement?
agreement, well, that I don't find, well, I must.
You have to tell us, no, before we decide
Certainly,
this
certainly.
application.
Madam, I pray before your lordship, subject I will place before lordship. Well, either they vacate the premises or they acquire it under the,
That's right. Who appeals for the respondents? What is your view? I mean, payment is something different. He will have to put in some more facts for us to decide what is to be paid. But if you're not paying and if it is not really needed, why don't you vacate the premises? Are you interested in remaining in that premises?
If I may most humbly draw your lordship's attention to page 200 of the law.
Can you answer the question first? Can you answer the
Well,
question first?
the stand
We
of
will
the
look
government-
into every document before closing this appeal. But you tell us one thing.
Well,
Do you really need to stay in the premises of a factory which has been purchased by the petitioner? I mean, we do not know what is the purchase price, but that's a property which is purchased. Now, if you need it for state's interest, for national interest, of course, he'll have to allow that.
indeed,
He can't evict you. You're not a private tenant.
lordship.
But then there has to be something, no, what was the arrangement under which you
This
entered?
is land which falls under the sixth schedule, my lord, page 201 of your lordship's brief. This is land which falls under the sixth schedule. There can be no truck and barter, my lord. In lands falling under the sixth schedule to the constitution, there can be no truck and barter between private.
Who's asking for truck and barter?
My lord, they say
That's
that
what
they
I
have
said.
bought, if
You
they
take
say
this-
they bought the land, the land could not have been purchased, my lord. That's the
Where
stand.
have you questioned that? Where have you questioned that? Don't
And
make
well,
such statements which are not supported by facts, no. We are in appeal.
It's,
Did you raise that plea before the division bench or before the single judge?
well, that appears in the judgment, my lord.
How do we know? You tell us. Where is that? Where is that part in
Well,
the judgment? Show us.
201 of your lordship's
Page?
201 of your lordship's brief.
Could you tell us the paragraph?
The first paragraph, my lord.
Hmm?
However, the petitioner, 1, 2, 3, 4, 5, fifth line from top, my lord.
Which paragraph?
First paragraph from top, page 201 of your lordship's brief.
First paragraph.
He's, my lord, para 19, my lord, past para 19. Sorry, my lord, I'm off. Line 5 from top.
Yes.
However, the petitioner has failed to submit any documents in support of the claim.
Read the entire paragraph.
He submits that Kavi Anglam
No, Mr. D. Mazumdar. Read from there.
Yes, my lord. D. Mazumdar, so for the state of Assam, respondent submits that the land in question has not been requisitioned at all under section 3 of the Assam Land and Requisition and Acquisition Act, but only fix the rent in pursuant to the direction of this court, which is fair. Provisions of the Assam Land Requisition and Acquisition Act 1964 is not applicable at all, as the same has not been invoked in the present case. He submits that so-and-so situated at Dilaji, Dipu, Karbi Anglong has agreed to provide spare some accommodation for establishing battalion headquarters, CRPF. And accordingly, Woodcraft Products Limited had stated that they would not charge anything against the said accommodation. Once the promise is made that the land would be provided free of charge for the said accommodation, doctrine of promissory estoppel demands that the parties cannot go back on its promises without giving due notice. He submits that apart the ownership of the premises as claimed by the petitioner has not been proved. There is no proper transfer of the premises except
That
the
was your statement. That
Yes.
was the statement of the additional advocate general for the state of, for the respondents. Where is that? How do you say so? How was it met with? Where are the submissions of
Since
Mr.
there is
Saraf?
no- but the next line, since there is no valid transfer of the premises, no title or ownership is conferred, which gives right to the petitioner for claiming compensation rent.
That is not an issue which was ever discussed by the land single judge
Even-
or by the division bench.
Even it says therefore without going to the claim, concurrence regarding to the whether say that ability transfer.
That's right.
It does not even.
What is, when did you raise
Right.
that plea that it is not a valid, he is nobody to claim rent? Where have you said that? This statement is absolutely vague. See, there is something called Article 300. Would you agree or not? Sixth schedule or whichever schedule.
Yes.
Right.
There
So
it is there.
we are not asking the owner to evict you. We are not forcing you to make any payment. But then can you keep this in continuum? And not pay the electricity charges, don't do anything, you don't even challenge. Where have you really raised this plea that the transfer, so it belongs to which party? Not the Woodcraft and not him. So it becomes, is it,
Council, madam.
Huh?
Land belongs to the Autonomous Council.
Autonomous Council?
Yes.
And before that, why did you have to seek the concession of Woodcraft? If that was so, can you make such submissions in the air?
Accommodation to celebrate by the deputy commissioner family.
If I may most humbly pray, since it was Mr. Mazumdar who was arguing this
That's-
matter, can it be taken up there?
We definitely, we would accommodate. Mr. Saraf also has to do his part.
My lord.
Now, every time, we can't render him, we can't reduce him to the position of a shuttlecock, no? Throw him from here, go before the authority. Authority would decide something on the same lines. He comes before the single judge, that is challenged in division bench, again some order. And this has been happening for 5 times over.
Lord.
There has to be a quietus to this, no?
Indeed, my lord.
And you can't take that plea that it does not belong to you, it does not belong to the person. If it were your property under Schedule 6, kindly hear MS Sharma, you will be confronted with this question.
My lord.
Just making a statement that it belongs with the Schedule 6 applies, that doesn't cut much ice. Then you could have entered the premises without any concession. Why did you agree to pay even the rental? And if electricity, we would like the state also, I mean, this is under which concept? It's a 6 schedule. Who appears for Karbi Anglo? Now, if the electricity is not being paid for, no, MS Sharma, you remain, you're the main party here, don't decide. So, Karbi Anglo government, why is it continuing with the electricity supply?
The penalties was coming to the CRP appointed.
I am asking a totally different question. We understand that CRPF 13th Battalion, then 9th Battalion, then 2nd Battalion, all right. If it is necessary for the maintenance of law and order for state's administration, all right. But can you deny payment to the and what kind of an argument is this? That
we are only curtailing autonomous companies concerned on the part of the petitioner in accordance to law.
so you have not questioned it.
We are not questioning.
You have not questioned, just a minute, you have not questioned the transfer of the property, 59 acres of land by Woodcraft to the petitioner, to the appellant. Where is that?
Logical look into my lord, paragraph 23 of the last one. Is
Judgment is,
my lord,
Do-
you can find the affidavit, it put a single judge, and that affidavit, you have stated that.
what?
Regarding my lord, transfer of the liability of the petitioner, my lord, to the my lord, autonomous.
Where have you said so? Let us see.
Logical look into the paragraph 23
Para of?
of the last one. On the other hand, it's very good standing. While raising the maintainability of the maintainability, the section 4 of the.
Is this the issue? You're saying something else, Mr.
Next page, my lord.
Mr. Chutia, this is something else.
But our it's here.
We are happy that you have taken this ground.
Uh,
We are happy that you have taken this ground. Why don't you continue with this ground and just not jump on the bandwagon of MS Sharma?
That is the main ground, and there is a statutory provision is there for determining the land under the Assam Autonomous.
That comes later, Mr. I'm finding myself absolutely stuck up with this. Rental, fair assessment of rent, that's what I told you. So fair assessment of rent comes only when you decide that this veneer, what is this name, what is the name of the appellant? Bizarre Veneer and Sawmills. That is, this is the owner of the property. If you admit this, then we go for fair rent. All right. So what you're saying is something different. What is recorded in the judgment is absolutely on a different premise. So first you have to say that this land, you have not obstructed, you have not laid any complaint with respect to the transfer of the land, which you're authorized to do. Because you have the special powers
Fine.
under the sixth schedule.
Fine.
And you must have framed some law because you have the legislative powers also. So where is that objection? I don't think any one of you are ready with the
The
brief.
transfer has been allowed at page 146, your lordship.
Mr. Saraf and Mr. MS Sharma and Mr. Chutia, this is not the way we go about. You first be sure on your facts. We will be asking questions. You tell us, there are three things which are very important. Now, MS Sharma, I don't know where from did she get an idea that the land does not belong to the appellant. If she raises this issue, this has to be decided first. Right?
60 years.
If this issue cannot be raised here in appeal, if that has not been raised earlier, look at the court first before conferring with amongst you all.
If your lordship kindly take the table of page 147.
Mr. Saraf, please.
My lord, I'm sorry.
That's not the way. You just find out, take one plea which is acceptable. We decide we are here. We would have referred the matter back to the single judge again, but then that would not look proper. That is shirking the responsibility. We need to do that. And unless you raise that issue before the court, Mr. Sharaf is not expected to bring that on record that he has purchased it. He had the authority to purchase and the Woodcraft had the authority to sell the land. Where have you raised it?
Well, page 159 of the lordship reads, the affidavit filed by the SCO.
No, therefore, Mr. Chutia, you have not taken that plea, fortunately. You have taken the plea of fair assessment. Now we will deal with it. First, please find out. This is piecemeal argument. We don't understand.
Only one page, if your lordship just takes the table, only one page.
Yes.
Page 147.
What does it say?
But it is, they have transferred and taken the.
That letter we have seen.
But they have
That's by the Deputy Commissioner Karbi Anglong.
My
That we
lord,
have seen.
Joint Secretary, my lord, this is the Joint Secretary, my lord, at page.
Why did you not object to it when this question was raised before the division bench?
My lord, when the land has been transferred, the transfer fees has been taken by them district council, my lord.
They can't now blow
Now,
hot and
my lord, how they
That's
can,
right. That's right. So MS Sharma doesn't have that stand in her. She doesn't have that point up her sleeve. Mr. Chutia, you tell us.
Page 308.
And who represents the CRPF? What is your instruction? Forget about stand. What is your instruction? Are you really interested in occupying the premises? So state would be this Karbi Anglong. No, Karbi Anglong. Who are you representing? MS Sharma? State of Assam is a formal party. Why did you jump on this? State of Assam has nothing to do with this. Mr. Chutia, you will have to take instructions.
7, 8, 9, and 10.
Fair assessment is all right. But where is the compulsion that they would continue keeping you as tenant? It is your responsibility to place the CRPF.
No, my lord, it is not our.
Whose responsibility?
It is the responsibility of the district administration, which is under the state, my lord.
Yeah.
We have only the limited power. Law and order situation is not with us.
Not.
For keeping the force, for maintaining the law and order situation, state provides.
I think I'll call the advocate. Mr. Saikia, can I just request you to come? Something has to be done in this.
Lordship.
It has been continuing for a very long time. Either you say, just find out, check up the records yourself. There's a request from the bench. Of course, you have.
Yes, I was listening to the. Lord.
See, there are 3-4 things which have to be decided. It has not been decided by the single judge or by the division bench. This property was purchased with the approval of the council. There is an order passed which is on record. So now the other side cannot take the plea that this is not the property and therefore it is no man's land and we will enter. That otherwise also would not have been correct. Because otherwise Woodcraft held the land. They have purchased it from Woodcraft. Now if there is no agreement with the CRPF for allowing them without free of cost then perhaps the principle of caveat emptor would not apply. Right? If he has purchased it, he must have the full enjoyment of the property. Article 300 of the Constitution, it may not be a fundamental right, but it's a constitutional right. Now, he does not want to evict the CRPF battalion. He only wants a fair assessment. The matter was referred by AAAC for fair assessment. Fair assessment is all right, but 15,000 for 52 acres of land. What is the process? Whether they would like to continue, whether it is necessary. All these aspects have to be gone into, and then we shall decide. Every time asking a property owner to go to authority, come back to the court, doesn't look nice. Right? So you just see, we are giving you 2 weeks. Just find out and tell us what can be done. Take down. A factory premises located in Karbi Anglong, which was originally owned by Woodcraft Products Limited, had been purchased by the appellant in the year 2002. It appears from the record that in the year 2000, the 13th Battalion of CRPF was temporarily accommodated in the premises for maintaining law and order in the area. Perhaps under an agreement with the landowner / Woodcraft Products Limited, that nothing shall be charged for such occupation, and that the CRPF would vacate the premises whenever such occupation would not be required. Stop. It further appears from the records that the premises remained under the occupation of CRPF with different battalions at different times entering the premises. The main concern of the appellant before the learned single judge, as also before the division bench, was payment of rental, as also the electricity charges for the use of premises, which had been let out / permitted to be occupied temporarily by the CRPF. After a prolonged litigation, a direction came forthcoming from the courts for an assessment of the rent, which was calculated at rupees 2,35,599 per month. This calculation of the rental was unilaterally reduced to 15,893 per month by the government, which, according to the appellant, was in complete disregard to the independent valuation and assessment conducted by the relevant authorities. The appellant therefore prays that such arbitrary, unjust reduction ought to be interfered with. During the course of arguments before the division bench, a new plea was taken that perhaps the appellant did not have the right to claim any rental as the transfer documents were not placed on record. This was seriously rebutted by the appellant, and documents were produced indicating that proper permission was accorded for the transfer. In that view of the matter, we, while hearing this appeal, found it to be necessary to request the learned Advocate General to look into the matter and tell us whether, and inform us whether the CRPF would require the premises for the accommodation of battalions, and if so, for what time and under what terms and conditions. A property right of an individual cannot be taken away lightly without the due process of law. We are astonished to learn that neither electricity charges are being paid, nor any rental is being provided to the appellant who has purchased 59 bighas of land from the erstwhile owner under appropriate orders passed by the Karbi Anglong Autonomous Council / the state government. Is the electricity charges being paid by the CRPF or the state government is also a question which confounds us. The learned Advocate General has assured that he will look into the matter and get back to us with necessary stand of the government with respect to the occupation of the premises of the appellant. Come on, by the next date, re-notify. We give you 3 weeks. Let us conclude it now.
Lord, I'll get completely. If not.
On highly appraisal.
29-8. Item number 10.
Yes,
The applicant here in your lordship was running a fair shop, your lordship.
yes.
Therein, a false case was being filed upon him and he was being convicted by the court below. And thereby he was convicted for 7 years. And he had preferred an criminal appeal, which is pending before the Honorable High Court. And the sentence has been stayed. Thereby suddenly the shop license was being cancelled by.
Let us see the Assam Public Distribution of Articles Order 1982. There must be something there
Yes.
for continuance of the license. Not
Clause 7.
necessarily, I mean, there are different kind of,
Yes.
control orders.
Yes,
There are some states which say that if you are convicted of any offense,
yes,
the license will be cancelled.
yes.
Some say that
Yes.
only if under some order, some offense under the EC Act,
Yes,
which concerns your functioning.
yes.
If you have been convicted there, your license would be cancelled. Not convicted, even if you're being prosecuted,
Yes.
even if a FIR is lodged within 6 months. So let us see the clause 7 relevant.
The
clause.
clause 17, your lordship will find in the page 42.
On which page is it? 4.7. Whether it's 4.7.
Let's see.
Page 42. Page 42 of the upper page.
Let's see the,
Page 42 in the imbuing order, there is a 42. Point number 7.
this is an appeal.
Internal page 3 of the judgment.
Judgment ऊपर में लगाएंगे. Where is the copy of the
Page
judgment?
42. Front menu like that.
We don't have the judgment here.
And I think 2 page 40.
There's no judgment here.
Oh,
Internal page,
Page 42, para 7.
wait, in the picture. That goes.
when a licensee has been convicted by a court of law. Or no, I don't think it has been correctly reproduced. We'd like to see the original, the book. Let's see that order.
This is fine.
Yeah, that's all.
Yeah, it's in.
Because
No, this is. I don't think
this cannot be. If a licensee has been convicted by a court of law for contravention of any law.
So, meet the order. You get it. I'm all agree with it. Some public distribution. Still also business. But some public distribution. Some public distribution.
Public service then.
Is going to give you for now.
What is the system here? Once the license is cancelled, it is again advertised, given to somebody.
Yes, Dr.
So that somebody must have been given the license, no? This was cancelled when?
Is
10/4/2025.
2020.
So within 2 months, no place can remain without a fair price shop.
But it is not yet handed over.
It has not yet been handed
Not
over.
been handed over to anybody. And Lordship, my humble.
Where is the provision for appeal? You preferred an, I mean, there is there must be some provision for appeal
There is no appeal provision.
against the order passed
Against
by
the
the
order
concerned authority.
There is no appeal provision.
Let us see that.
Order, control order. You give the essential,
Eight-
some essential commodity that there is the control order. There is a control order, different control orders are
It must be a quick compilation.
quick compilation, not this direct.
Anyway, if you can get hold of the original gadget or the photocopy of it, will what is there printed in the book does not appear to be grammatically correct. All right, so you'll have something to argue, otherwise it's a closed case. देखना original gadget हमें दिखाओ. We
Lordship,
are adjourning the matter for
if
some
in the
time.
long run he is being proved not guilty, Your Lordship, that's
That, Mr. That is not a ground on which we can interfere, no? Your personal discomfort, your, the compassion, it's not a place here. We can understand you have been convicted for 324, which has got nothing to do with your job as a fair price shop dealer. Now, if you are convicted under the Essential Commodities Act for black marketing or something, perhaps situation would have been different, but then we need to know what kind of an order, the control order says what. Don't look so dazed. You have to come prepared, no? Again, as prayed for. Show us the control order. They are not able to find it out. Show us the control order, the original gazette notification, if you can find out. You can always download it from the main source and then give it to us.
Lordship may fix on Thursday or Friday.
As prayed for on behalf of the appellant, re-notified next week, Monday.
Next month. 11 A.
Limited opening to you.
Yes.
If it says for convicted for contravention of the control order, then you have a case. If not, you don't have a case. It is not or, it is for.
Yes.
All right.
Item 11.
Yes.
May I please, Your Lordship? My Lord, the matter relates, my Lord, we have challenged a particular provision of the, my Lord, Rule 14, Sub-Rule 1 of the Assam Secondary Education Provincialized Service School Rules 2018, my Lord. My Lord, the ground for challenge is that, my Lord, in that rule, my Lord, provision has, under the proviso, it had been laid down that the seniority of the graduate cadres, my lord, the graduate teachers in the secondary level schools shall be counted from the date of receiving the graduate scale of pay. Now, my lord, here
And
it-
that pay you receive only when the institution is provincialized.
provincialized, that is correct, my lord. Now, my lord, the date of initial appointment and joining,
Would that be relevant?
yes, my lord, because that is the basis and the foundation of our service of becoming a government employee, my lord.
Not necessary. Let us see the rule.
My lord, may be pleased to find in the manual, my lord. Lord, I have
Give us
also,
the manual.
I have also annexed the rule also, my lord, my lord,
Let's see it from the
page
manual.
107, my lord.
Manual.
Education manual, education. My lord, for a quick reference, my lord, I have also annexed the gazette also.
Where is that?
My lord, may be pleased to find at page 107, my lord.
Yes.
Here is the provision, my lord, 107, rule
Let
14.
us see what is this Assam Gazette Extraordinary Government of Assam Secondary Education Department notification of 2019.
My lord,
Now, let us see clause 3.
clause, my lord, we are agreed with the clause 1, my lord.
Just a minute.
My lord,
Read clause 3.
my lord, my lord,
The application portion is necessary, no?
my lord.
These rules,
Yes, yes.
Mr. Bhuya, we are at page 106.
My lord, I'm sorry, my lord. My lord, page, in exercise of the power.
Never get flustered when I raise my voice. It's just my habit.
No, my lord.
Don't feel disheartened. Don't feel offended. We are
No,
only interacting,
No, my lord, not at all,
right?
my lord.
So don't say sorry and all that.
My lord.
I'm only referring to the page.
These rules, my lord.
These are you refer to 107.
My-
We are asking you to come to
My
page
lord,
106.
I'm reading, my lord.
3.
My lord.
Yes.
These rules shall apply to the employees appointed for the teaching and non-teaching purpose in the senior secondary schools, higher secondary schools, Assam High Madrasa and High School, which have been provincialized under the Assam Secondary Education Provincialization Act of 1977.
Therefore,
My lord.
the foundation is laid here.
My lord.
What you rejected in the first instance, it is laid here. Now, this rule applies to the teaching and non-teaching staff
Exactly.
of provincialized
Under
schools.
1977, my lord. But
Now-
my lord,
now
we,
proceed.
my lord, now, Assam Act, so and so, Hansar Education Act of 2011 and the Junior Colleges Act 2012 and the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. Now, under this 2017 Act, my lord, we were provincialized, my lord. So therefore, this rule is also made applicable for us also, my lord. So now, my lord, our very limited contention, my lord, is
Read
that.
14 now.
Yes, Rule 14, the post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidate amongst the graduate teacher as per the district-wise seniority list on the recommendation of the district selection committee constituted under Rule 16, Sub-Rule 2. The selection of headmasters and superintendents shall be based upon the seniority and satisfactory annual confidential report for the last 3 consecutive years as per the procedure provided under Sub-Rule 3, provided that the seniority of the graduate teacher shall be determined from the date of receiving the graduate scale of pay by the respective assistant teachers. This is the, my lord,
This proviso controls.
this proviso controls our future, my lord, because, because, my lord, why? Rule 24, my lord, if the seniority has also been fixed under the Rule 24 also, my lord. Just for a moment, I beg to draw my lordship's attention, my lord, to Rule 24 also, my lord. My lord may be pleased to find is at page 109, my lord. Rule 24, Sub-Rule 1, my lord. May I read, my lord? The seniority of a member in a cadre appointed by the direct recruitment shall be determined according to the order of preference in the respective select list finally approved under Rule 8, Sub-Rule 2 in respect of the postgraduate teachers and in respect of or graduate teachers. If he joins the appointment within 15 days from the date of receipt of the order of appointment or within the extended period as mentioned in Rule 19. If a member of service, my lord, in sub-rule 24, sub-rule 3 is relevant, my lord. The seniority of a member of the service in a cadre who joins in a school otherwise than by direct recruitment, that is on transfer or otherwise, shall be determined as per the date of joining in the school in the concerned cadre. If a member join in the school through transfer from schools of other district, the seniority shall be determined from the date of his joining in the school in the concerned cadre, and the seniority in the earlier school of other district or in the same school in a different cadre shall not be taken into account. Now, my lord, we were neither, my lord, transferred nor in any mode of appointment we were there.
Doesn't concern you.
My
Now
lord,
come to page 110.
my lord,
In so many words, in so many clauses, in so many provisos, it has
Well.
been made clear. Provided that in case of the second proviso,
correct, my lord.
at page 110,
Graduate
provided that in
seniority,
case of a graduate teacher, the seniority shall
Getting
be counted from the date of getting salaries meant for a graduate
my lord,
teacher.
my lord,
So you get a graduate scale only on provincialization.
my lord.
Therefore, that date is relevant. Why do you say it has to be struck down as ultra virus or something?
Because, my lord, the past services, my lord, which we were given for the for the purpose of
That we
provincialization.
understand, but why this notification,
Because, my
why
lord,
this rule?
because, my lord,
Does-
now,
Does
Hello.
the government have the power to frame this rule or not?
no, my lord, we are not
So
questioning
therefore,
competency.
if
My-
you're not challenging the competence, if you're not challenging the otherwise generality of the provision, then
Rationality,
then what ground do you challenge the constitutionality
my
of
lord,
it?
we are challenging that the, my lord, the equality, my lord, which we were equal with the other graduate teachers, my lord, once we provincialize. Now, by virtue of this, my lord, proviso, we have been classified into two different classes, my lord.
That class is
My lord.
just one minute. एक 2013 इतनी कटा No discrimination. It's a very reasonable thing. Yes, Mr. Sykes.
What they want is that they want the seniority to be counted during the service in a venture, which is not perfect.
No. They are perfectly entitled to question the validity of
Validity, they don't have any
notification.
single grounds, neither it is, we do not lack competence, neither it is violation of any fundamental right,
Nothing.
and no more ground is available for.
No other ground is available. And he says that this classification is illusory. No, it is not.
Reasonableness is there.
The learned single judge, this has not been
Validity.
decided. It has been challenged for the first time. Take it. Anything else, Mr. Bhoya?
My lord,
Before I start dictating order, I give a notice to the council.
I
We are
know.
dismissing your petition, anything you want to say.
my lord,
So that later outside court, you don't say that I was not heard.
no, my lord, that my lordship is always given a fair opportunity of hearing.
So there's a notice to you. We are dismissing the petition. Tell us anything else that you want
My
us.
lord, may I pray for a notice at least, my lord, that for the
Well,
reply?
it's here, Mr. Advocate General is here. No?
My lord, because, my lord, what my, my lord, submission is that, my lord,
Oh, I now repent that I gave you this notice. I should have started it.
My lord,
If further instruction is yet to come, then lordship, can it?
my lord, may,
Further instruction, for further material,
That will be nice.
further material instruction.
no, my lord, very middle class people, so my lord, we are not expecting that too much, my lord.
All right, so let's be done.
So, my lord,
Let's finish.
my lord, yes, my lord can pass a order, my lord.
Heard Mr. Bhuyan. Heard Mr. A.R. Bhuyan, learned advocate for the and the learned advocate general assembly. The writ petitioners are graduate teachers in arts, science, and Hindi subjects who were initially appointed in their respective schools between the years 1991 and 2003. After they had rendered their services in non-provincialized schools, their services were provincialized as assistant teachers in their respective schools since 1/1/2013. Stop. It was only after that date that they were granted the graduate scale of pay. They had been, based on their performance and service records, entrusted with the responsibility of in-charge headmaster in their respective schools, which was a kind of an additional responsibility by the director of secondary education. While doing that, they were also entrusted with financial powers in their roles as in-charge headmasters, which responsibility they claim to have been discharging since the provincialization of their services. The director of secondary education, however, by letter dated 23/9/2023, had issued instruction to the respective inspectors of schools to fill up the vacant post of headmasters in accordance with Rule 14 of the Assam Secondary Education Provincialized Schools Service Rules 2018. Based on that instruction, the inspector of schools, Jorhat District Circle, prepared a gradation list dated 17/3/2025 for consideration of eligible candidates for the post of headmaster. The names of the writ petitioners were placed much below in the gradation list for the reason of their services being counted from 1/1/2013, when, after provincialization of their services, they had been granted the graduate pay scale. The petitioners contend that their seniority should have been calculated from the original date of joining, which dates back to period between 1991 and 2003. Stop. Not doing that would be discriminatory and, for no intelligible reason, creating a class of such teachers such teachers. The government of Assam Secondary Education Department notification dated 18th of September 2019. Came out with the Assam Secondary Education Provincialized School Service Rules 2018, framed under the powers conferred by the proviso to Article 309 of the Constitution of India. The rules referred to above have been made applicable to, amongst others, the teachers who were provincialized, whose services were provincialized under the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017. Rule 14 of the rules of 2018 referred to above clearly specify that the post of a headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from candidates amongst the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee constituted under Rule 16(2). The selection of the headmaster and superintendent shall be based upon the seniority and satisfactory annual confidential report for the last 3 consecutive years as per the procedure provided under Sub-Rule 3. The proviso to the Rule 14 further clearly specifies that the seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective graduate scale of pay to the respective assistant teacher. Rule 14 2 the proviso to Rule 14(2) of the rules of 2018 further provide that graduate teachers shall include the cadre of assistant headmaster for the purposes of selection to the post of headmaster, and the seniority of the assistant headmaster shall be counted from the date of joining as graduate teacher with graduate scale of pay. Rule 24 of the rules of 1989, of 2018, sorry, rules of 2018 further clarifies the situation with regard to seniority of such headmasters. Seniority of the members of the cadre. The seniority of a member in a cadre appointed by direct recruitment would be determined according to the order of preference in the respective select list finally approved under Rule 8(2) in respect of postgraduate teacher or graduate teacher, comma, if he joins the appointment within 15 days from the date of receipt of the order of appointment or within the extended period as mentioned in Rule 19. The last of the provisos in Rule 24 again clarifies that in case of graduate teachers, comma, the seniority would be counted from the date of getting salaries meant for graduate teachers. And that in case of contractual teachers, comma, the seniority shall be counted from the date of absorption in the sanctioned post carrying regular time scale of pay. The seniority of the headmaster of ME/MV school subsequently amalgamated with higher secondary/higher school shall be counted from the date of getting pay in the graduate scale of pay. Thus, for all practical purposes, the rule of 2018 specifies that the seniority shall be prepared only from the date when the teachers start getting the graduate scale of pay, which in the case of petitioners was only from 1/1/2013 when their services were provincialized. When their services were provincialized under the Assam Education (provincialization of services of teachers and reorganization of educational institutions (Act 2017). The contention of Mr. Bhuya, learned counsel for the petitioners or petitioner, and counsel for the petitioners, is that the notification is hit by Article 14 and 16 of the Constitution of India for the reason of such distinction being arbitrary and the classification being without any rationale. No purpose is served in reckoning the seniority only from the date of provincialization. For it ignores the recognition of prior service rendered before provincialization. In this context, it has been argued that even before provincialization, none rendered before provincialization. It has further been contended that the gradation list prepared by the inspector of schools is not sustainable in the eyes of law, as it does not account for the actual length of service and fails to provide a fair basis for promotion. The further grievance is that the gradation list is absolutely flawed, as it impinges upon, as it impinges unfavorably upon the promotional avenues of the petitioners. All these grounds have been noted only to be rejected. The services of the petitioners were provincialized on 1/1/2013, and only thereafter they were paid the graduate scale. They were put in the graduate scale. In exercise of the powers conferred under proviso to Article 309 of the Constitution of India, the Assam Secondary Education (Provincialized School Service Rules 2018) have been framed, which clearly specify that the seniority shall be counted from the date when the teachers start receiving the graduate pay scale. Full stop. The seniority list shall be prepared in accordance with that, which will have a life of 1 year. Full stop. Pursuant to such framing of rules of 2018, efforts were made to fill up the posts of headmasters, fill up the vacant posts of headmasters in various schools. And for the purposes of effecting the filling of such, effecting the recruitment, effecting the filling up of such posts, the gradation list was prepared. The seniority/gradation list was prepared. The petitioners name do appear in such seniority list prepared by the inspector of schools, Jorhat district circle, but they are placed below for the reason of their services having been provincialized only from 1/1/2013. The rules have been properly framed with a specific provision for the seniority and the gradation list/seniority list, which under such circumstances, the petitioners have not made out any case for interference in the seniority/gradation list prepared by the inspector of schools, Jorhat district circle. We do not find any reason to interfere with such seniority/gradation list of the petitioners. The petition does not have merits and is best dismissed. ऐसे लिखो, ऊपर में लिखना. It may not be out of place here in this context to mention that initially the writ petition was listed before a learned single judge. But considering the fact that Rule 14 of the Rules of 89 was under challenge, the matter was referred to the judge.
Obligement, highly obliged.
Item 12.
The list is a bit being here. Yes, item number? Well. Yes.
May I please your lordship? Lordship, I am the petitioner Dhubi District Samas Kalyan Shramik Nirman Union. Lordship, I have filed this public interest litigation on behalf of large number of people who are suffering or affecting due to non-completion of a RCC bridge number 5/1 over River Tipkai, my lordship. My lordship, as per the tender agreement, the bridge was started 20/08/2019, and as per tender agreement, it is supposed to be completed 2021. But after 2021, we have been given various representation to the authorities why the bridge has not been completed. My lordship, we have filed a representation, my lordship, 24/02/2025 to the office of the chief engineer, my lordship, PWRD Khana Sanmari, to the office of the executive office in the Blashipara civil subdivision, to the office of the chief secretary. My lordship, no response have been given by the authorities, my lordship. In fact, my lordship, we have filed an RTI, my lordship. Even the RTI report has not been given. But fortunately enough, all the information we have inquired in the RTI, my lordship, all the information we got through the Honorable Minister, PWRD, replied in the floor of Assam Assembly on question being asked by Honorable MLA, my lordship. So in that reply, Honorable Minister of PWRD replied that there are two reasons have been provided, my lordship. As for our respectful humble submission, that reason is not satisfactory because the suffering is tremendous, my lordship, humongous, my lordship. Due to this, my lordship, if you see in the photograph I have attached, my lordship, that the two places are connected, my lordship. The Chaudhuriswar Bazar and Phulkatari, only through that place, my lordship, river has been crosses. And this is the only connectivity area, my lordship, for large number of people have crossed each and every day, my lordship. There is only one engine boat is used for communication purpose, my lordship. And large number of people each and every day has crossed the river, my lordship. And sometimes what happened, my lordship, there are some.
That's all right. Yes, what do you have?
This is,
Why has it not been completed? The completion date was 2021.
this has come for the first time. Lordship, give me some time. I'll take the instruction. Only one aspect, kindly take.
So what instruction? You just have to tell us, your MLA had put a question. On the floor of the house, the minister informed that 62% of the work. was
Yes,
done.
my lordship, yes, indeed.
Correct. So 40% of the work, till what time would it be concluded? I think a good government would always cancel the contract and the work order to the builder and would retender it if he is unnecessarily delaying the man. And put him to saddle him with exceptional cost. 4 years delay is good ground for cancelling the entire contract, giving it to somebody else. If it doesn't have the wherewithal, then there could be 3-4 factors for the delay. Number one, you may not be disbursing funds on time. We don't know. Since it is coming for the first time, you must know. If you are disbursing funds, then perhaps there are some impediments, some obstruction which has to be removed by the state contractor, cannot do it on his own. The third is the contractor must be a class 3 kind of a contractor who would have taken the money and gone away. And the fourth would be that you're not interested and you're not putting any pressure on him, the PWD minister, or whichever, the construction, whichever ministry it falls under.
I'll definitely take the instruction. Let's give us some time. Only one aspect. I would like
What
to-
aspect? We don't want any aspect to be discussed here.
No,
The bridge, you have started the work, 60% of the work. There is one engine boat. Think about students who have to go to school. All that you have to do
pregnant
is,
ladies
just a minute.
that is all.
All that you have to do is to
That is all.
let
okay.
the contractor know that if it is not completed within that period, plus you will also have to ensure that it is built properly. Any collapse of the bridge, as has happened in the past, not here, but somewhere else. You have to keep the health card of the bridges. What point did you want to flag?
My lordship, sometime what happened, my lordship, due to the non-availability
Allow
of the
him to
engines.
speak, no, government, let the government council say something.
Only the credential of the petitioner. I will also obtain an instruction on that, because the petitioner is a credit union and they in the representation.
Forget about that.
They are an NGO.
Forget, according to, maybe your high court rules would say that his identity has to be known, it's a public. Otherwise also, if you would have known.
As regard the cause, I'll take.
Suppose I would have read it in the Sentinel or Purvodaya Prahari or whichever, you would have taken up this matter.
Yes, lordship, and always. Lordship, in many cases, I have also seen one.
That is not an issue. Don't divert your gaze unnecessarily to other aspects.
No, I'm just pointing it out. But I'm not trying to divert, I'll take the instruction.
Again, this public interest litigation has been filed by Dhubri District Samaj Kalyan Nirman Shramik Union with a prayer for a direction to the authorities to complete the construction of RCC bridge number 5/1 over Tipkai River under Alamganj, Phulkatari, Bondi Hana Road via Joruar Char in Dhubri district project. The sanctioned cost of the project is around 26.20 crores. The bridge was necessary for the local people who, in the absence of such a bridge, are dependent on engine boats. According to the tender agreement, it has been submitted, construction was supposed to be completed by 20th of August 2021. However, as late as in the month of March 2025, on a question being asked to the concerned minister, the House, the Legislative Assembly was informed that 62% of the work of the bridge is over. Mr. Dean, learned counsel for the respondent seek some time to take instructions on the matter and report to this court as to the stage of the construction and the possible time within which the construction would be completed. Let such information be put on affidavit by the next date, 4 weeks.
Deeply obliged, my lord.
8-9. Item 13.
My lord. My lord, kindly peruse page 72, my lord.
Tell us the matter, then we ask us to come to the page. What is the issue?
Issue, my lord, regarding, my lord,
Payment of family
family
pension.
pension, my lord.
Why has it not been paid to you?
My lord, because, my lord, stating, my lord, I have not completed 5 years on, my lord, in the year 1970, my lord.
And where is that rule?
Rule, my lord, kindly page 72, my lord. This is the office memorandum, my lord. Where is reflected, my lord.
Page?
Page 72. No.
Page 72.
72, my lord. It is annexure 6 to the petition, my lord. In pursuance of the government notification dated 29/11/2005, amending
72, 1 second, let me come. Yes, this is the office memorandum.
office
of
memorandum.
2005.
That is reflected, my lord, regarding amendment of Rule 98, my lord. Amending note to Roman 9 below Rule 98 of the Assam Service Pension Rules, the government of Assam, with a view to provide relief in families or prorate pensioners is pleased to allow payment of family pension to the state government employees who are permanently absorbed in the state public undertaking at 30% last pay drawn on the date of permanent absorption, subject to the lowest ceiling of minimum pension fixed by the government time to time with effect from 1st December 2005. The petitioner joined in service 1967, my lord, and thereafter, my lord, he permanently absorbed Assam State Corporation, my lord, in the year 1977, my lord. And accordingly, pension proposal submitted.
Where is it? Where is the requirement? Undertaken, just, let's see. Circular, P1, P7. That is
No, that is circular that is talking about. And the 31st of March. Yes.
My argument, my lord, basically on whether that office memorandum.
Just a minute.
My lord.
It was 2 years short. And the corporation does not have the provision for payment of family.
No one.
First December 2005.
That is not a question. Question is like, nobody can get pension from those two. The corporation does not have any. Corporation people, if they have worked in the state prior to 1970 for 5 years, they will be entitled as a foreign service deputation. And that is not there because he got appointed only in
60, 69, and it was 2%.
Therefore.
Sixty-nine.
And what does the SAM service? So ultimately you retired as an employee of the corporation.
My lord.
So unless the state government would have recognized your services as a foreign deputation,
But permanently absorbed in the year
you
1977.
may
my
have
lord.
been permanently absorbed. That is the issue. We require,
What is
this
the
requires to be heard. You file your response affidavit. This requires to be heard. By this memorandum, you can't be the pension rules cannot be. Whether he was treated as a foreign service or having served for 35 years.
My lord, may I pray one? May I point out? If lordship can come to page 121, the notification of 1970. This notification is neither challenged in page 121. This is impugned judgment. This
You are
notification
appearing for?
for the 8th December.
Yes. Please. That's good.
No,
This notification says, my lord,
who appears from the state of Sam?
She's-
Transport department, I am appearing.
You file your affidavit.
No.
Let the affidavit on behalf of the respondents, especially the state of Sam, be filed positively by the next state. We notify. You also put in your response. We are not asking you, the corporation, we are not asking you to pay family pension, not at all.
well,
Therefore, don't show us that. We are on the question whether this rule, by this amendment, by this memorandum of, by this notification, could the statutory pension rules be changed? That's the issue. But the difficulty here is that you retired in 2002.
this notification came in 5.
2005.
This notification came in 2005.
Yes.
All the more reason for him to say, but after so many years, what have you been doing? Prior to 2005, there was nothing that could have been done.
My lord.
You would not have got pension at all. It was only later that it was made pensionable, subject to your having worked with the state government for 5 years.
That is as per notification of Office Number 1970. They have to comply first one
Anyway,
1970.
he has survived for so many years, 25 after retirement. What is the date of retirement?
Retirement, my lord, retired on, my lord,
No. What is the age of retirement?
60 years,
60
my lord.
years.
60 years. You retired in 2002.
Mal-
That time you were 60.
Mal-
So 23 years. You must be 85 years.
My lord.
By now.
And when did you file this petition?
My lord,
Petition, not the appeal.
petition filed in the year 2018, my lord.
Not for this.
23,
23, well,
23, my lord.
23.
My lord, the process is going on, my lord. My lord, immediately after retirement, I have filed pension proposal paper before the authority, my lord.
Lordship, in our affidavit, Lordship, we have stated that affidavit that for the.
And-
And he was the employee, no? Not the family member. Anyway, file your up. File your
Lordship,
My lord.
6 weeks.
Obliged.
Okay.
15-9. Item 14.
Yes.
Please, your Lordship, matter may be adjourned for the day, Lordship.
Adjourn for the day.
Lordship.
Why? Anyway, you want an accommodation, we'll grant. Pass over for the day. Tomorrow.
Item 15.
May it please your lordship.
Yes.
But Lord, I can have to this may. It lordship should kindly have the act, my lord.
Just tell us the issue first.
Yes, issue is, my lord, I was appointed pursuant to selection by the Public Service Commission to then Municipal Administration Department, my lord,
As appointed as
as an
assistant.
assistant engineer.
Okay.
After 1 year, I was deputed to this board, my lord,
What is this board?
Urban Sewerage Board.
Okay.
Now, my lord, if your lordship should kindly come to section 22, it's not a per se deputation. What had happened, my lord, the moment board was constituted, all the employees of the state government in the public health engineering and other departments were transferred to the board, my lord. Please, yes, please have section 22.
No, we'll say that, but first
Yes.
you argue and then.
Yes. Now, my lord, my case is I retired as a chief engineer
Of the board.
of the board.
Okay.
Now, under the relevant provisions of this statute, once I come over to the board, my condition of service will be not less favorable than it was under the state government, including pension. Now, I'm sought to be given CPF, I'm claiming regular pension. Now the honorable single judge, my lord.
No, you're claiming CPF.
No.
You received CPF.
I received CPF, but
Uh-huh.
I'm claiming regular pension, my lord. Because under the act statute, that is
That's
guaranteed.
right, but then.
Now, my lord, learned single judge says, I am not entitled to this because I was not a permanent employee of the government of Assam.
Is that the reason, or the reason is
That
that?
is one of the, that is one of the,
Accepted CPF.
no, that is one of the principal reason. Para 26 of the impugned judgment. I think, my lord, that's a serious error. It's a scrap in the judgment. If your lordship should kindly take the impugned
No,
judgment.
That reason may be faulty, but the other reason that you have
No, my lord,
accepted
my lord,
and merely your.
by repaying the, my lord, amount with interest, I'm entitled.
It doesn't work like that, Mr. Chaudhary. Anyway, let's see.
Yes.
Let us see.
Yes. Now, just for your lordship's kind.
One second.
Yes.
Give us 1 minute.
Maybe para 26.
It shows from judgment.
Yes. If you lordship would kindly come to page number internal page 10. Para 26. On top.
Yes.
There is no doubt or dispute about the fact that the petitioner's service under the board was non-pensionable. In other words, board is a non-pensionable establishment within the meaning of Rule 36 of the Rules of 1969. Therefore, the writ petitioner was not entitled to receive pension for the services rendered under the board. Now, this is, since the writ petitioner was not holding a permanent post under the government, nor did he fulfill the requisite length of qualifying service for receipt of pension under the rules of 69, as on the date of his permanent absorption under the board. Hence, he had also not acquired any right to receive pension, even under Rule 31. As such, this court is of the opinion that Section 22(2) of the Act of 1985 would be of no avail to the writ petitioner insofar as his claim to receive pension as a government servant is concerned. This, in my humble understanding, is wrong. If your lordship would kindly permit me to place the act, that makes the position very clear.
You retired when?
I retired on, my lord, 2020.
2020.
One second, I'm giving the date.
For about
31/1/23. Immediately, I lost the claim, my lord. Now, if your lordship would kindly have the book for a moment, my lord.
Yes.
I'd like to read section 22.
This is?
This is the urban, the name of the act is Assam
Urban Water Supply and
Yes.
Sewerage Board Act.
Act 1985. Please have section 22, my lord. Save as otherwise provided in section 8. Persons who were either employed in the public health engineering organization of the government of Assam or under a local body exclusively in connection with urban water supply and sewerage service or sewerage works or sewerage farm shall from the appointed day hereinafter in this section referred to in the act be transferred to the board, and they shall hold their offices or services therein by the same terms and the same remuneration and upon the same other terms and conditions and with same right and privileges as to pension, gratuity and other matters as they would have held the same on the said day, if the said act had not come into force, as the case may be. The aforesaid water supply, sewerage, service work and sewerage farm had not been transferred to and vested in the board and shall continue to do so until their employment in the board is terminated or until their remuneration or other terms and conditions of service are revised.
That's true.
Yes. Now please come to
Please
two.
come to proviso and two.
Yes, my lord.
First proviso and then two.
Yes. Provided that a permanent employee of the state government whose service has been transferred to the board shall hold lien of the state government and take periods spent in the service of the board shall be reckoned for increment, pension and other terms and conditions of the state government rules in the event of his returning back to the state government service. Now, two is important, Miller. Every officer or employee of the state government whose services have been transferred to the board shall intimate the state government writing within 2 years from the date of transfer to the board. Please come to Roman 2, Miller. That he should be absorbed substantively in the services of the board, and then the board will absorb him substantively in the services, and thereupon the services rendered by him under the state government shall be treated as services rendered under the board, and he shall be entitled to have such right or to such similar rights in the change situation with regard to remuneration, leave and pension, as will not be less favorable to the service condition, agreement rights, as he would have entitled to before he was
But
employed
you
in the.
would not have written that letter, no?
My
What
lord.
reason? But you would not have.
No, my lord.
Within 2 years.
In fact,
because- One
this,
second, Mr.
in
Chaudhary.
fact, this had happened.
You would not have, I mean, I'm not challenging you on facts.
Yes.
You would not have done that. That presumption is there because you would have started contributing to the CPF.
Yes.
So therefore, this clause takes away your right to now claim it after retirement.
No, my lord, there is one catch. my
The
lord.
only,
Now there is a letter written by the board, my lord, to which the state government replied that answers the query. Now at page number 33, my lord, a
Of-
letter was written by the
number
board,
33 of
uh,
the
12/7/96. Writ appeal.
33 of writ appeal.
Yes.
Yes.
Now, this is a communication from the managing director with reference to the above. I'd like to point out the following matter before the government in connection with absorption of Sri Azizur Rahman, assistant engineer of this board. Rahman was working on a part-time basis with effect from 3/7/89 to 9/4/90. During this period, he was drawing his salary from the director of municipal administration. Since 10/4/90, he was taken on deputation to Assam Urban Water Supply and Sewerage Board. He was drawing deputation allowance up to 14/11/95. The government of Assam has indicated the decision to allow absorption of Sri Rahman by letter dated 26/10/1995. Subsequently, in the 18th meeting of the Board of Directors of the Assam Urban Water Supply and Sewerage Board held on 7th, the board approved absorption of services of Sri Azizur Rahman. In the light of the above facts, and as Sri Rahman took deputation allowance under the Foreign Service Terms and Conditions up to 14/11/95, it was decided to absorb him in the board permanently with effect from 15/11/95. In this regard, we request the government to enlighten us from which date absorption of Sri Rahman to the board should be counted. Now, the answer is at next page, Miller.
Yes.
With reference to a letter on the quoted subject, I am directed to say that Sri Azizur Rahman,
This page is annexure 5.
annexure 4, Miller, page 34. With reference to a letter on the quoted subject, I am directed to say that Sri Azizur Rahman, assistant engineer, should be absorbed substantively in service of the board, and then the board will appoint him substantively in the board under section 22(2)(2) of the Assam Urban Water and Supply and Sewerage Board 1985. The service rendered by him
1 second.
in the state government shall have to.
1 second, Mr. Chaudhary.
So virtually in terms of 22(1), Miller.
And what is this requirement of indicating to the government?
So that will come only in case of that proviso, but now I'm covered by the first clause because of this letter, Miller, of 22 subsection 1.
Right, you have been absorbed, but within 2 years of your absorption,
Yes.
you have to say.
No, that will happen only when, my lord, in the subsequent, please have that once again, my lord. Is section 22.
Very difficult proposition, Mr. Chaudhary.
Yes. I don't say it's.
It's not a clear-cut case where
Yes,
you
yes.
have a right, because you have accepted it. See, apart from the rules and statutes, you were actually acquiesced. You went for CPF.
Because
Now
it is a,
asking you to return the money and then take pension. that is-
because it pertains to pension.
Forget about this. We are on the issue of your having contributed and taking the contribution of the government
No, my lord,
for
as
27 years.
in some of the judgments, Supreme Court has said, my lord, if you are prepared to return, then they will get, I'm
That is-
prepared to return.
Well, those do not set the precedent.
No, my lord,
Those are-
this letter perhaps clarifies my position that my case falls under 22(1).
Just a minute, this letter was of 1996.
Yes.
And what were you doing for all this?
No,
time?
because now I am covered by 22(1).
No, you
Therefore,
may- you may-
that exercising that option part does not come.
No.
Now, kindly see, my lord.
Let's see.
Yes, the option will come only when it is covered by 2.
Just a
I am
minute.
covered by 1.
Now, please ask us to come to that page. Which
Yes, section 22(1). Save as otherwise provided in section A, say 8, persons who are either employed in the public and engineering organization of the government of Assam or under a local body exclusively in connection with the urban water supply or sewerage service or sewerage work or sewerage firm shall from the appointed day be transferred to the board, and they shall hold their office or service therein by the same terms and the same remuneration and upon the same other terms and conditions and with the same rights and privileges as to pension, gratuity, and other matters as they would have held the same on the said day if this act had not come into force. So by saying that from 5/7/88, I stand absorbed, my lord. That means, my lord, my services stands transferred on the coming into force of the act, following coming into force of the act. Now, only when, my lord, it is covered by section 2, in case of a transfer, my lord, that a question of exercising option would come.
No. I will read it differently, Mr. Chaudhary, subject to what we say. Now, look at this. 22(1) you have read.
Yes.
Now, you become part and it shall not be, the privileges would not be less.
Less favorable.
Right. Now read the proviso.
Yes.
That clears the whole thing. You have to read it
Yes.
very subtly. In fact, they have not been very clear.
Provided that a permanent employee of the state government whose service have been transferred to the board shall hold lien under the
So
state government.
therefore, till the time.
And the period
just
spent the board.
just a minute. Before your absorption,
Yes,
permanent employee of the state government, you are not even permanent.
I'm permanent, my lord.
I
That
think
is
you are
well.
That's factually incorrect. So
Yes,
it's all.
I'm
So
permanent.
suppose you're a permanent employee of the
Yes.
state government, your services were transferred to the board.
Huh.
You shall be holding a lien
Huh.
under the state government and therefore whatever period spent in the board would be treated as in government service.
Huh.
This requirement therefore, and this provision therefore makes it incumbent upon you that notwithstanding 22(1), you have to indicate that you shall be treated as what? And if you don't do that, and you have not done it for the simple reason, let the state write anything, but the state has contributed. This is a situation of lack of communication. You have made a very ingenious argument, very assiduously built up, but no, we can't accept it for two reasons. Look at this. Now the proviso has to be read adjustem generis, correct?
But my lord, provider will neither limit nor enlarge the scope of the original provision.
Original is all right, but
Ah.
proviso
Ah.
only explains. It is explanatory.
It only qualifies the proviso.
It qualifies because it makes it very clear.
Hmm.
Proviso says
Hmm.
there are two aspects of the matter.
Hmm.
One, the moment you come to the board,
Hmm.
the services under the state would be counted
Yes.
and you would get all privileges what you got in state.
Hmm.
This proviso to it says that when you come to a board, you continue to have a lien. You continue to have a
Of
lien.
course, yes.
And if you return to the department,
So that,
the service of the board shall be treated as service of the government.
yes.
Now, this therefore makes it abundantly clear that everybody who gets absorbed or who goes to a board has to go through 22 also, 22(2) also. Through a process of reasoning. Otherwise, this was irrelevant. Otherwise, this was irrelevant. And therefore, the necessity of 22(2) that every officer or employee of the state government whose services have been transferred, so and so.
My lord, another problem would be in
Now,
that
have
case.
you followed the logic in what
I
we are
followed,
saying?
my lord. I'm only trying to understand because between.
You are absolutely right to the extent
Hmm,
that once the original section gives you that privilege
yes,
of having your services counted, not only services counted, but all the leave and pension and other will not be less advantageous than it were in the state. So far, so good.
Hmm.
So this happens only till the time you don't indicate. Because otherwise you're on state lien. Now, I'm reading it backwards. Otherwise you're on the state lien. If you're not on the state lien, you are supposed to tell.
1 second, my lord.
You can.
I'm getting over. My lord,
Just have a look at it another time.
yes, my lord, let me have
Please.
client, also
difficulty-
instruction
the
from our
difficulty with
client,
us
my
is-
lord, whether
The
this
difficulty with
2
us
years
is-
I follow.
Mr. Chaudhary, the difficulty with us is that if we prepare ourselves with one reading, it's very difficult to change
Right,
sides.
sir.
Just take 24 hours, not
Yes.
tomorrow. This is what I'm saying.
Day after, my lord.
Day after
Wednesday,
tomorrow,
yes.
anytime.
Yes.
22(1) and 22(2) has to be read together
Harmoniously.
harmoniously. Otherwise, the whole purpose would be defeated. Number 2, you have not indicated that is for sure. Otherwise, the state would not have, the board would not have contributed. And you have contributed your part. You have accepted it for 27 years. That is one aspect of the matter. This, you can always argue that you're ready to return with all interest, everything. But should it be done now? Because this letter at annexure 4 that you have shown is against the facts which are there in your service record.
No, but for that letter, my lord, perhaps I would not have hesitated this.
So this letter is a miscommunication. Just have a look at
I'll
it.
have a look at it.
Because to my mind, if you
No,
have
I've
the
followed, my lord. And secondly,
it
my
is-
lord, I'm
it-
not very sure
see,
about this option
propo-
part.
This proposition is only if you read it backwards.
Yes, yes.
You read it from 22 and then proviso and then 22(1).
In any
That's
case,
the logic. But
because uses them generis will also come into play, my lord, when it comes to the proviso.
proviso to adjudicem generis has to be read, otherwise it will be absolutely different. And the purpose also is very clear. It's one after the other.
Oh, my lord, to be honest, my lord, the view taken by the single judge that I was not a permanent employee.
that we
Therefore, so and so.
no,
This,
agree.
yes.
We overlook that statement. That is wrong. You were a permanent employee and this was not a kind of absorption like particular case absorption. It was wholesale absorption.
Exactly, wholesale.
Therefore, all the more important that this rule will follow. It's only because of that lien part.
It will look fine. And I got it, my lord. I'll try to satisfy your lordship.
All right. I'm
On the
giving,
after tomorrow.
I'm giving you time only for the reason that you change your gaze and then see.
Yes, yes.
All right. As prayed for by Mr. Chaudhary and Senior Advocate, re-notify. We keep it next week.
Anyway.
Next week, Monday.
11.
This week would be slightly difficult for me. We are
11th in Itanagar bench, my lord, the some youngsters are waiting us, my lord. So we'll let it on 13th, my lord.
13th I shall be traveling. So 14th.
14th.
14th. Because
Yes.
this week my
Mind is there.
mind is there.
In fact, my lord, the bar has organized one, program for the youngsters, my lord. So we have been invited to say a
Yes.
few things. On 11th, I'll be there.
It would be a welcome sight to see bar of Gauhati being represented there.
No, my lord, not only that, we should interact with the youngsters, my lord.
Yes.
Because they are the new entrants in the profession. Unless we
Yes, yes.
share our experience, how do they grow, my lord?
Yes. That's of utmost importance.
Yes, yes.
In the controlled, atmosphere of the courtroom, outside courtroom, which you don't have at other places. It's a different place altogether,
Right.
provided we live up to that, expectations from the bar and bench, of course.
Of course.
Bench, of course. All right.
Deeply of course.
Item 16,
Yes,
May it please your lordship,
yes.
here the petitioner lordship has availed a bank loan from a respondent bank.
Hmm.
Yeah, in spite of not defaulting in the payment of the EMI installment, lordship, they have served a SARFAESI notice.
SARFAESI Act, you should have gone under section 17.
Lordship, this is a illegal proceeding, so I am before the.
No.
Fair lord.
Go before 17. Go SARFAESI Act. Satyavati Tandon tells you to go before that. Any measure. Go before that. Don't have an adjudication by us. Again, after some arguments, the lead counsel for the petitioner submits that he be given the liberty to approach the authority under section 17 of the SARFAESI Act 2002 for redressal of his grievances. First up, the prayer is allowed. The petitioner is permitted to challenge the order of the bank, challenge the decision of the bank and the other authorities under section 17 of the Act. The writ petition stands disposed of accordingly.
Lordship, till then, no coercive action may be taken.
We can't say you apply immediately.
Much obliged.
Obliged.
item 17 and 18,
See, once a loan goes bad, SARFAESI proceeding is initiated. We otherwise, see, you're a purchaser of the flat.
Yeah.
You should have gone straight away, not wasted your time here.
Lordship, here the account is not classified.
Tell you next.
Lordship, here the loan account has not been classified as NPL.
That's right. So that's a good ground, no?
Yep.
That's a good ground. Plus the possession has not been taken. The district magistrate has not done that. There is a time limit. So where is the apprehension? He has not done that. Go before the concerned officer under 17. Yes, next.
Obliged.
17 and 18.
Yeah, please, your lordship.
We'll rise for a while. We'll come back in 5 minutes.
No.
Yes.
Yeah, please. Lordship, item number 18, your lordship. I have filed a affidavit in reply today morning, your lordship. And therein I have annexed one order of the Honorable Apex Court, your lordship. Probably the affidavit is not yet.
No, what is this case about? What do you want to say?
Lordship, the matter pertains to a wildlife sanctuary called Garbhanga Wildlife.
Louder.
Garbhanga Wildlife Sanctuary.
Garbhanga.
Garbhanga, yeah.
Yes.
It's in Kamrup Metro District only.
All right.
And so there was a preliminary notification which was issued.
Hmm.
Thereafter, after around say 15, 16 months, your lordship, a U-turn was taken and it was de-reserved, your lordship, without obtaining the leave of the Honorable Apex Court. So there is an order, as well as your lordship, your approval of the National Board for Wildlife, your lordship. Now, your lordship, the state has taken a stand. There are a number of villages, your lordship, tribal forest villages within the sanctuary. Now, that issue, your lordship, is addressed by the statute, it's addressed by the notification, as well as an order of the Apex Court in a similar matter, your lordship, which has a bearing in this case. If I may place the order of the Apex Court, your lordship, for a moment, your lordship.
Mr. Counsel,
Yes,
please don't take offense at what I'm going to say.
lordship.
I mean, this is a desultory way of dealing with it. First, you tell me what actually happens. We'll look at the Supreme Court judgment.
Lordship,
We'll look at the orders. You know, what has happened,
yes.
why it has been withdrawn. Forget about the stand. You tell us the basic facts, then we'll ask for the stand.
Yes, your
So Garbhanga Wildlife Sanctuary, there was a preliminary order. What I
Yes.
could understand from your argument is that there was a preliminary order of the government
That's,
converting this forest into wildlife sanctuary.
yes, your,
That preliminary order was withdrawn.
yes, your lordship.
Why?
Yes. So they have taken a stand in their affidavit, your lordship. There are some forest villages, Khasi village and Garo villages, within the wildlife sanctuary,
Yes.
your lordship.
Yeah.
Now, within, if your lordship come to the notification itself,
हाँ, पहले बोलिए ना, you first speak and then you
Yes.
will see everything.
yeah, so they are saying that the villagers have been residing for more than around 100 years or so, your lordship. So now, your lordship, that their rights, they have to settle. That is what they are saying. Now, the statute
Is that the reason for their withdrawing this preliminary objection?
because, your lordship, in the notification, there is nothing is mentioned, your lordship, and we don't know the content of the cabinet decision.
Mr. Can I have your name, please?
V. Rajkumar.
Huh? V. Rajkumar.
Yes.
Rajkumar.
Rajkumar.
Mr. Rajkumar, but the issue, you have come up with a different issue altogether, no? Forget about the stand of the state. We will question the state. We will put them on the right track. There is no difficulty.
Lordship.
You perhaps say that this notification was withdrawn.
Yes, your
This was withdrawn because the railways were trying to bring a track there through the forest.
No, that is a stand.
And
Your
then that was the survey made. And
lordship.
then you say that since it has been withdrawn, people have started mining illegally. So,
No, lordship.
you have come here with what purpose, you tell us. We see that purpose and ancillary issues, we deal with it.
Lordship, there are two PILs. Your lordship, one PIL, they are primarily on the issue of railway track inside the Garbhanga Wildlife Sanctuary. What we are on, your lordship, because the Garbhanga Wildlife Sanctuary, once the wildlife sanctuary is declared, preliminary notification, and subsequently once the final notification issued, then, your lordship, an eco-sensitive zone has to be notified. Because the purpose of your lordship declaring a, yes,
You have first questioned the withdrawal of that preliminary notification,
yes, your lordship.
correct?
We are firstly challenging the withdrawal of the notification.
Right? And next,
And, your lordship, because there are a number of wildlife, your lordship. Because the wildlife sanctuary give a higher degree of protection than a reserve forest, your lordship. And the eco-sensitive zone purpose is as a shock absorber, so that there is a buffer between the wildlife sanctuary and the settlements. Also, there are certain industries and activities which are prohibited within the around the wildlife sanctuary. Now, if the wildlife sanctuary notification is withdrawn, your lordship, then these activities will come up around the wildlife sanctuary, your lordship, which will again lead to conflict between human and animals, your lordship. And it will also affect the biota of the wildlife sanctuary. So that is our case.
that's one thing.
Yes.
Now, railways, have they completed their survey?
Now, on the point of railways, my friend is, I am not on the, mine, I am primarily, I am challenging the notification, your lordship. The railways,
What does the state say?
so the state has
Not
now,
from the mouth of the state, but you tell us what is the
Yes.
stand of the state.
now the state is saying, your lordship, that there are a number of villages which have been there for 100 years. So because of that, they are facing certain difficulties to settle their rights. Now, when they issued the notification in 2023, they were aware that these villages have been there for 100 years.
Can you show us that notification by which this proposal was withdrawn?
Yes, your lordship. It is at page 41 of the PIL, your lordship. PIL 62, your lordship. I mean PIL 62.
No, they are at PIL 66.
Yes.
PIL 62. Page?
Page 41, your lordship, annexure B. September 23, in pursuance of the cabinet meeting decision held on 25/8/2023. Lordship,
Let me come to that page.
lordship. I'm sorry.
Yes.
Annexure B, your lordship. Notifications, 26 September 23. In pursuance of the cabinet meeting decision held on 25/8/2023, by file number so-and-so, the governor of Assam is pleased to cancel the preliminary notification on Garbhanga Wildlife Sanctuary issued by number so-and-so dated 28/3/2022 with immediate effect. Now, there is no ground that is shown here, your lordship. It mentions about a cabinet meeting decision. Now, we are not aware of what is there in the cabinet meeting decision, your lordship, unless the state plays the record.
Yes, Mr.
My lord, what has happened? It is a reserve forest of 1926 and we have filed an affidavit. There are two forests, my lords. These are Rani and Garbhanga. My lord, they still maintain the status of reserve forest. And what has happened, my lord, the petitioner's case is that without taking the permission, which he is harping on the Supreme Court order, he says that without taking the permission of National Wildlife Board, we cannot alter the boundaries or cancel. But that step that will come in only when we issue the final notification on 26. The final notification was never issued, my lord. It was never converted to wildlife
Okay.
sanctuary.
Forget about that. Permission part we ignore for the time being. But tell us why it was withdrawn.
My lord, there are some certain difficulties we are facing, my lord.
Have you put it on record?
Yes, we have put on record. Moreover, lordship, it still maintains its status as reserve forest, which is also protected by Assam Forest Regulations and the Forest Conservation Act, my lord, of
Let us
1980.
let us see the reason.
My lord,
Let us see the reason for.
reasons, my lord. The lordship will take the affidavit we have filed in PL 66. It covers, my lord. 66.
Mr. Gogoi,
My lord.
can you give me a comprehensive, statement with respect to both the PILs? Give us a
In
comprehensive-
66, PL 66, we have covered both the issues of railways and also the grievance of the presentation, my lord.
Page,
Lordship will see kindly. It flows from the page 137, paragraph 10. It indicates
page 137.
137, my lord. It speaks of a report of the ground authority, which is the DFO, my lord. It reflects a report.
1 second.
It's a para 11 of the DFO report, Annexure D.
With the declaration of a wildlife forest, what changes would have come?
My lord, gets an extra layer of protection. The if funding is done by the wildlife, and MOEF looks after it, then some other restrictions have come into play, my lords. It's described in these sections of the Wildlife Act, my lords. There will be a prohibition in the entry. There will be certain extra layer protection, my lords. And the everything will be scheduled, and it gets a status of a more elevated status of a protection. my
So
lords.
tell me one thing, this preliminary notification, could it have been issued against area which comprised any reserve forest or territorial water? Can it be done?
Yes, it can be done,
Can
my
be
lords. Yes, it can be done. Because section lordship sees, my lord, it flows from section 18 of Wildlife Act, my lords. The government can, my lords.
Can we have wildlife act?
My lords. Wildlife protection in 1972. The first opening words, my lords, the state government.
One second.
My lords.
The preliminary notification, what happens?
Well, after preliminary notification, also will see the section 19 to 25, there's a procedure laid down. A collector is appointed. He inquires into the rights and privileges, my lords.
That covers the forest rights, your lord. 19 and 24, your lord.
Then,
And after that, my lord, will kindly come to 26A. A final notification is issued.
So why does section 18 say the state government may by notification declare its intention to constitute any area other than the area comprised within any reserve forest or the territorial waters as a sanctuary?
My lord.
What is the meaning of that? That's what I was asking about.
Yes, my lord, that is a specific
You say no.
question. I was under the impression that reserve forest
No,
also.
don't
can be
get that impression. Therefore, we look for the statute. If you can't make a sanctuary in the reserved forest or territorial waters, then perhaps this very intention was wrong. No?
Yes,
Lordship will come
that I have to admit, I just read it. That is wrong because the words are specific that within a reserve forest cannot be done.
Lordship will probably come to 26A, 1B, Your Lordship. The intention probably, because in this case, what has happened, there are.
Yes. The,
26A,
number one is
1B,
this is 1991 insertion, declaration of
declaration of area sanctuary when a notification has been issued under section 18 and the period for preparing claims have elapsed and all claims, if any, made in relation to any land in an area intended to be declared as a sanctuary have been disposed of by the state government, or, Your Lordship, the next B, Your Lordship, any area comprised within any reserve forest or any part of the territorial water
Is to be
which is considered by the state government to be adequate, ecological, faunal, floral.
Therefore,
So therefore,
the certification of the state has to be there for otherwise declaration of sanctuary, any place could be declared a sanctuary. But for a reserved forest or any part of the territorial waters, if the state government considers, it has to say that it is for the purposes of adequate ecological, faunal, floral, geomorphological, natural or geological significance for the purposes of protecting, propagating or developing wildlife.
yes,
That has to be included.
that
Is
is,
to be included in a sanctuary.
yes. So it is in consonance with, it.
1 second.
Yes.
And where is the concept of reserved forest? Which section?
It's under Assam Forest Regulation, my lord. So it's another statute.
Let's see.
Assam Forest Regulation 1891.
Now, Mr. Gogoi, you have to tell us what is this? Other than a reserve forest. 18.
My lord. Well, perhaps the intention of 26A
Perhaps is not answer.
B maybe because
You read
when
the
a-
entire section and then tell us. We will.
well, a notified reserve forest is already there. Objections are there.
If a sanctuary is created, the state government is under an obligation to specify the limits
My lord.
and say that this part of the reserve forest
Yes,
also
yes.
could be part of
Yes,
sanctuary.
yes, my lord.
That is what 26A, 26 capital A subclause E says. May the point.
Definition in this.
This may be a-
Definition. It's 6. 25 people.
Forest regulation, my lord, there is a notification, preliminary notification under section 5.
Section 25 B. So then we can take that. And you understood that.
That's section 20. Indian Forest Act then.
It was. My lord, this is the
Or anything.
Or even otherwise, if
these are reserve forest of 1882. Another one is, my lords, of 1926. Lordship will find the notification in my affidavit.
He has to find out. Mr. Gogoi, you have taken a very simplistic stand.
My lord.
Now just find out. There are two aspects of the matter. We'll have to go through the entire act, you know. The notification, the preliminary notification under section 18 cannot be issued for reserve forests. That is one. The reason it can be found that for reserve forests, if it is declared to be a reserve forest by the state government either under the Indian Forest Act 1927 or under the state act, then with the notification, there has to be proclamation by forest settlement officer. And till the time the proclamation is made, there will be no new settlers. And the forest settlement officers shall decide about the claims of the persons, especially with respect to Jhum cultivation. So therefore, all these rights have to be decided under the state act. Now, therefore, the reason in section 18 to say that the intention of the government's notification of the wildlife would not include areas which comprise the reserve forest. Because here also there is treatment of claims. There also there has to be treatment of claims, but under the Wildlife Act of 1970. Right. So here it would have been presumed that all the rights would have been, all the claimed rights would have been decided. So therefore the reason. So this is because you just pass a notification without ascertaining any reason. You recall, you start extra layer of protection, all right, but could you have done that in the reserve forest, where there are many claimants and they are exercising their forest rights? So please check up, examine, and then tell us.
But the petitioner's case is, my lord, that we have.
Forget about petitioner's case, Mr. We are not concerned with his rights.
My lord.
We are concerned with the conservation of forests.
My lord.
You tell us, then in that context, we will find out whether the recall of that order was correct or not.
Lordship, may I place one order, your lordship?
Mr. Gogoi, are you not understanding what we are
I
trying
got
to
it,
say?
my lord, but.
Then what are you talking about his rights?
No, my lord.
We forget the face and the name and the case of the petitioner in PIL.
Well, I get it.
Mr. Gogoi, you have to tell us, no, in that case, if you are able to tell us and demonstrate, then we'll say that it was not required. And then perhaps they will lose out on case. What is their prayer? Forget it.
I'll get it, my lord. Lordship will list it
But
after.
in the process of selection under section 18, if at all some part of reserve forest is to be included in the sanctuary, then perhaps a notification under the Wildlife Act would have to be issued, and then it has to be specified by the state government. It's all a process. It's a composite process where this notification was not required. Therefore, you have rightly withdrawn and withdrawn by, because it was a reserve forest from before. That's a good answer.
My lord,
So why are you looking at him?
my lord,
You tell us what you answer our question.
my lord. I have to question the policy makers. my lord.
As prayed for on behalf of the, then we shall conclude it by saying that you could not have, and therefore you have recalled. This forest, this reserve forest area is having all the protection, the rights are being decided, but then you'll have to come with another affidavit. Just don't give me such piecemeal affidavits.
My lord,
And this had to be inspected by you before filing your affidavit, no?
my lord.
Unless you see the act every time, there's a possibility of going wrong.
My lord. I get it.
As prayed for on behalf of the parties. You also wanted some adjournment. You have brought something on record which is not here.
Yes, I filed my affidavit in reply.
As jointly prayed for on behalf of the parties, re-notify this case on, give a date sometimes after 3 weeks. We must know everything. Read the entire thing
My lord.
and then tell us. On that day, we'll be asking you which section, where, what, everything.
Answers will be given, my lord.
Give the date.
Yes. 26/8.
26. Public.
Okay. Yes.
Item 19.
Madam, last occasion on 22nd of July, Lordship has directed us to file an affidavit bringing on record the SOP in regard to felling of tree, Madam. And whether the translocation or felling of tree.
You filed that?
We have filed the affidavit on Saturday, we could file. I
Is
have,
it here on record? Let it be on record. List this matter and look here. Pursuant to order dated 22/7/2025, the affidavit with the SOP for translocation of mature trees has been filed. However, the same is not on record. Let that be placed on record by the next date, re-notified next Monday, next Monday.
11/8.
We'll file our reply.
Lordship, you can do it.
Copy has been served to you.
Copy of which?
All right.
All right.
Item 20.
Yes.
But on the consideration, I'll just create a few facts before your Lordship. The petitioner was a grade 4 employee in the year appointed in the 95.
Yes.
He was promoted in the year 2018
Hmm.
on the basis of seniority come merit office member. Then this petition was dismissed, writ petition, the opposite party challenged his promotion on the ground that he is more senior. So it was dismissed on the.
Now, what happened? You were appointed on class 4.
Yes,
Yes. Then,
95.
Ah.
Then he was promoted in the year 2018. His promotion was challenged by his senior on the ground that he is more senior, so therefore his promotion is wrong. The learned single just dismissed the writ petition on the ground that both are not qualified.
What was the qualification?
Qualification on the basis of the office memorandum, it is HSLC. But on the basis of the rule, this is a rule is not applicable, only office memorandum is applicable. So therefore, my lord, he filed review petition, writ petitioner filed writ petition, and the present appellant also, my lord, filed a review petition because the present appellant was not heard because he could not come due to COVID and all. He also filed a review petition. The review was allowed. But on the same date, my lord, writ petition was allowed on the ground My lord, interfering with the promotion of the petition on the ground that in seniority come merit. My lord, seniority is given to precedent and merit is not considered at all. Just because the respondent, private respondent was a senior, so he is entitled to get.
It
So
was
the
the-
matter was remanded back to the authority. For seniority come merit, my lord, a concept, my lord, if I may place your lordship may know. My lord, 2010, 1 SSC 335. Seniority come merit, my lord, the merit has to be considered. If the merit is equivalent, then only the seniority will come. So that is the only
That's true,
ground.
but what was there to assess the merit?
There was nothing.
No, what was there to assess the merit?
My lord,
There was no examination.
I was already promoted. So this should have
You
been,
were promoted, that's all right. That was under challenge.
yeah.
But where was the question of assessing the merit? Because see, your records were seen. Is there any
No,
statement that you were
nothing
more
was seen.
meritorious?
Nothing was seen.
So therefore it went by seniority.
Only on the basis of seniority. This cannot be done, my lord.
No, no,
As per the 2010
this
SCC.
cannot be done. So tell us the way out.
Way out is, my lord, this, first of all, my lord, in the review petition was, my lord, allowed on the same day and the same day, my lord, petition was.
That is something different.
Yes, my
that
lord,
is-
the
that is on the
technical day, he could not even.
That is, Mr. Das, that is on the procedural aspect of the
My
matter.
lord, I understand, my lord, but this is
That
prejudice.
if you press that, we can issue notice to the concerned respondent, but otherwise not. Who appears for the state?
My lord, on that,
I'm appearing for the state, my lord.
What do you have to say?
But here, my lord, in the affidavit, we have admitted that, my lord, so far as the writ petitioner is concerned, my lord, he was senior to the, my lord, private respondent.
That's right. He is arguing something else.
My lord.
So there is nothing on record to assess his merit.
But if lordship direct, I can place the, my lord, entire record of the, my lord, department proceeding. my lord.
All right, let affidavit in this matter on behalf of the state be filed positively by the next day. Let notice also be issued to respond number.
respond private respondent, my lord.
He is appearing. my lord.
You're appearing. They, no notice to respond number 5 is required to be sent as MS. What is the name? Huh? So has appeared on his behalf. In case it is deemed necessary affidavit on behalf of respondent number 5 may also be filed by the next day. 3 weeks. But if they notice has been received. Let affidavit, let respective affidavits on behalf of the state and respondent number 5 be filed by the next day. De-notify also.
1st of September.
They will produce the record also showing how the petition was.
No, I will place the.
Affidavit means that only.
Yes.
Yes.
Always. The
For
matter will come after 2 weeks.
3 weeks we have said.
1st of September. For hearing, item 21 to 23.
Yes. We'll hear the appeal first. We'll hear you appear for the appellants, no?
No, he is for the amicus, their subjects.
So you are an amicus in the reference. Here you come. Let's hear you first. You have a right to argue because of your seniority and you having been asked to become an amicus to the court. We'll hear you, young man. We will hear you. Yes.
My friend appears for the appellants. I was here. 13 persons have been convicted, my lord.
Yes. Yes, sir.
My lord, 13 persons were convicted. In the
How many persons were put on trial?
These 13.
Huh?
These 13.
13.
Yes, all of them.
Out of them, all were convicted.
All were convicted.
Okay.
And so
And
was
death was given to whom?
only the one, Rajan Dole,
Rajan Dole.
is accused number one. The rest, of course, imprisonment for life.
They, all of them have been convicted under which sections?
302,
Hmm.
143,
Hmm.
201,
Hmm.
and 364.
And the others? The other,
Are all in the same section.
could not have been, no? 302 by 149 hoga, 302 by 34 hoga, something.
The
302 by 149.
Same set of questions against all.
All right. All right. Now place the FIR.
Page 5 of the offering. However, also may kindly come to page 5 in volume 1.
Yes.
Which is by one of the sons of the victim person. With due respect, I would like to inform you that on coming to know my father at page 5, Mila.
Yes.
Yeah. With due respect, I would like to inform you that on coming to know that my father Rajkumar Dole, mother Bonali Dole, and younger brother Titu Dole had gone missing since 10 p.m. of 28/8/2012. I came to my house along with my maternal uncles. I came to know from a special source that suspecting that my family members has been practicing black magic. The below named persons and the people of Bardua Sapori in a group had conspiratorially taken my father, Rajkumar Dole, mother Pranali Dole, and younger brother Jitu Dole to the bank of the Reed River from our house forcibly and killed them and thrown them to the Reed River. Now, my lord, he has named as many as 9.
No, he has named 8 and says 10 and 15 others.
Yes.
Is that correct?
Yes.
All right.
Yes.
Then
Out
what
of which
happens
below?
thereafter? Let's see the charge sheet now.
2 have been, rest have been not put up for trial. Only 2 persons have been put up for trial, namely number 5 and 6. 6 is Rajan Dole, 5 is Janma Dole.
Janma Dole. Only these 2.
These 2.
And rest others?
Rest are, they have not been named in FIR.
They are not named with the FIR.
Now, coming to the evidence, my lord.
So no,
It's
before that, evidence, before that, we would like to see the charge sheet. Did the other persons, I mean, their names came on investigation?
Yes.
Huh?
Yes.
So charge sheet was submitted against how many? Let's see the charge sheet first.
3, volume 2.
Page?
Is
Second one.
Yes.
Not sent up was 9 persons.
1 second, 1 second. Not sent up for 9 persons. So the absconders is 1. And
Put up for trial these 13 persons.
okay. Yes. Now let's see the charge first. Charge is paid?
8.
Yeah.
This is a description of the prosecution showing details that on.
Louder, sir, louder.
The prosecution story in brief is that
No, no, no. No, no, no. Is this the way charges have been framed? These are.
the training of the charge will get a formal charge volume 1 of the work.
First volume page 8. Comment charge by the court.
Page 8.
No, you read this page 331. Read.
The prosecution story in brief is that on 29/8/2012, Informant Sri Santanu Dole of Swenso informed the PS by lodging written Ezahar that on coming to know that his father Rajkumar Dole, mother Bonali Dole, and younger brother Jitu Dole had been missing since 10 p.m. of 28/8/2012, he, along with the maternal uncle, came to the father's house at Lohitsapuri village. That there he came to know that around 10 p.m. on 28/8/2012, on suspicion of practicing black magic, the Ejahan named accused person in cooperation with the village of Lohitsapuri conspiratorially took his father Rajkumar Dole, mother so-and-so, and younger brother to the bank of Lohit River from his house, killed them and threw them into the river. Accordingly, case is registered and the matter is investigated. During investigation, the initial state of investigation visiting the place of occurrence, it was known from the witnesses that the people of Lohitsapuri were involved in this case. On the basis of the secret investigation, later on it was suspected that almost all the people of the village were involved in this incident, and a total of 20 persons, including the Ajahan named accused persons, were arrested and forwarded to the Honorable Court. During the investigation of the case, as 3 successive waves of flood occurred in Majuli subdivision, and the flood water inundated the entire place of occurrence, making extensive search operations, the 3 dead bodies could not be recovered. Our spies even could not trace out any clue of the dead bodies till today. On the other hand, the arrested accused persons stated that they had cut the dead bodies into pieces and had thrown the same into River Suvansiri, alias Lohit River. As there is no chance of recovery of the dead bodies in future, so instead of keeping the case pending, the charge sheet has been submitted to the Honorable Court to the following effect. During investigation, on the basis of the statement of 20 witnesses and secret investigation, since the case has been found to be well established against accused these 13 millards for committing offense of punishable under section 302, 201 and 143 IPC. The charge sheet has been submitted to the Honorable Court for holding trial under said sections of law. During investigation, making several times.
All right, we have seen. Now please come to page 8 of paper book number 1.
This is the charge villa.
Yeah.
That all of you on or about 28/8/2012 at about 10 p.m. formed an unlawful assembly and in furtherance of the common object of the unlawful assembly, used criminal force and abducted Rajkumar Dole, Bonali Dole, and Chitu Dole from their residence in order to murder them. And thereby committed the offense punishable under 143, 364, and 149. Secondly, that all of you on the same day, time and place formed an unlawful assembly and furtherance of the common interest of committed murder of Rajkumar Dole, Bonali Dole, and Jitu Dole with the intention of causing death. Thirdly, all of you on the same day, this in furtherance of the common object and lawful assembly, after committing murder of the said person, namely Renso, was disappearance of the evidence of the commission of offense and thereby committed the offense punishable under 201, 149 IPC. Fourthly, that all of you in the same date, time and place formed an unlawful assembly and in furtherance of the common objective of the unlawful assembly impacted the aforesaid persons, namely Rajkumar Dole so the lay murdered the aforesaid 3 persons, caused disappearance of the evidence and abetted, instigated the commission of the aforesaid offense, thereby committed offense punishable under section 364, 302, 201, 109 and 149 IPC. So these are the charges here.
Now, let's see. PWs 1 to 8 have said nothing, no?
Nothing. My lord, that has not been, of course, incorporated in the paper book. But then as it appears on the judgment, it.
1 to 8, we are asking you a question. 1 to 8 have not said anything about any one of the appellants.
No, nothing.
So let's leave it at that.
Yes.
So we will read 9, 10, 11,
Yes.
12 and 13.
Yes. 9, your lordship will get at page 28.
Page?
Wait, 28.
38.
28.
Yes.
I know accused Limai Dole and Anil Dole. I do not know the.
Introduce the witness.
Pegu.
Is Ajay Pegu.
He is Ajay Pegu.
And what is he in relation to the deceased?
Nephew of the deceased.
Nephew of the deceased. Okay.
I know accused Limai Dole and Anil Dole. I do not know the other accused persons standing in the dock. I knew the missing persons Rajkumar Dole, Bonali Dole and their son Rajkumar Dole. As my maternal uncle and Bonali Dole was my aunt. On 28/8/2012.
Informant was which son? He is the informant also.
He is not the informant.
Who is the informant?
Informant is PW.
What is his name? Informant's name and PW? What is
Santanu Dole, PW 13.
Santanu, PW 13. All right. Yes.
On 28/8/12, the OC Gormur Police Station informed me that the aforesaid persons went missing. After coming to know about the same, I went to the Gormur Police Station. And then, along with the police, I went to the house of Rajkumar Dole and found the door of the house open. And found that all the persons in the house missing. From there, I, along with the police, went to the fishery, which was owned by Rajkumar Dole. I noticed bloodstain near the fishery and also found SIM card lying over there. My elder brother, Pawan Begu, also accompanied us.
Pawan has been examined.
Yes.
10.
10. Pawan Begu 10 lagi.
Yes, when we went to Thana then.
And then accompanied us. When we went to Thana, then the police informed us that the accused persons killed Rajkumar Dole, Bonali Dole, and their son. Police arrested the accused persons. After 2 days of the incident, police again called me to the police station, asked me to inquire from the accused persons that where they kept the dead body. Amongst them, I can identify accused Limai Dole and Anil Dole. On being asked, Limai Dole and Anil Dole told me that all of them have cut Rajkumar Dole, Bonali Dole, and their son into pieces and threw them into Subansiri River. Thereafter, police took the accused person along with Limai Dole, Limai to the fishery. I also accompanied the police to the fishery, and after reaching the fishery, accused Limai Dole produced one dhow from the rear of the fishery in my presence, which was kept by him and confessed before the police that he, along with Anil Dole and Atul Dole, Rajkumar Dole, Bonali Dole, and that's torn into pieces and thrown the dead bodies into
So
the
this
river.
confession was made before PW 10 in
Yes.
front of the police.
In front of the police.
And was he in custody?
He was in custody.
He was taken into custody when?
It seems from the record, my lord.
There are two aspects of it.
Yes.
If he is not in the police custody, then the recovery is useless.
Yes.
If he is in police custody, then it is no longer extrajudicial confession. It's a confession to the police, hit by section 26, correct?
Correct.
So now tell us the date of the arrest.
From IO's evidence we get, my lord. I think date of arrest goes in. That leading to discovery.
His confession. And he's in the police custody. That we will take what this extrajudicial confession from police was that is by.
Go to Tamil Nadu, that's it.
When was he arrested? Take the records.
Yes.
Record.
That's it.
Give the records to them. With the trust that there shall be no tampering with the records. That's in.
I arrested two of these persons I arrested on 38.
On?
61.
16.
I arrested Kampor Patil, Supply Patil, and Balisa Patil.
No.
Yeah.
We are concerned about this.
No.
Actually, they were arrested 2 days before. Actually, the dates are not being asked.
We'll find out, my lord.
Okay.
Concern about you, my and Abdul.
So they were in police custody. Okay.
Yes. Well, later on, witnesses also have confirmed. Cross-examination. This is not a fact that the accused persons, Utul Dole, Anil Dole, and Limai Dole do not confess at the police station that they killed Rajkumar Dole, Bonali Dole, and their son, and then cut pieces and they threw them in the river. They confess before me at the place of occurrence. This is not a fact that I have dispute with Limai Dole and Anil Dole. This is not a fact that Limai Dole and Anil Dole did not confess before me that they killed Rajkumar Dole, Bonali Dole, and their son.
I do not. Should you leave the last paragraph? I do not remember.
I do not remember when the police called me to the police station, when police informed me and called me to the police station. During that time, police did not arrest the accused persons. Police, after arresting the accused persons, again called me to the police station. When police called me, the police station, the accused persons were in the police lockup. I cannot identify the other accused persons other than the accused Limai Dole and Anil Dole. OC Gormur Police Station asked me to make query to the accused persons in missing language. Police took 3 persons from the lockup.
So last 4 lines, just read. That is important for us. Rest, we are not interested.
Yes. Please.
Both the dhows which were produced by the police in presence were lying in open space near fishery. Tell you next, PW 10.
10. We know accused. He is Pawan Pegu. I know accused Limai Dole and Rajan Dole. I do not know other accused persons standing in the dock. I knew the missing persons, Rajkumar, Bonali, and his sons. They belong to my village. About 1 year back, OC Gormur Police Station informed me that the aforesaid persons are killed by the village people. Accordingly, went to the police station and found the accused persons in the lockup. I can identify accused Limai Dole. Police asked the accused persons before me that who killed the aforesaid persons. The accused Limai Dole told that all the accused persons along with him killed them with a dao and concealed it. Police took the accused Limai Dole along with the other, I do not know his name, to the place of occurrence.
All right, cross-examination.
When police took the accused persons to the place of occurrence and Ozoy Pegu accompanied the police to the place of occurrence near the Subansiri River, I have not stated before the police that during investigation, police seized the dhow from the place of occurrence. I have not stated before the police that the accused Limai Dole in police station stated before the police that they had concealed the dhow in the place of occurrence and they will show the dhow to us. It is not a fact that the accused Limai Dole did not confess that the accused persons have cut Rajkumar, Bonali and his son. But I put my signature in Exhibit 2 covered by bamboo. Not covered by bamboo. It's not the fact that Material Exhibit 7 is not seized up. This is not a fact that accused were taken by police to the place of occurrence. This is not a fact that accused did not show the dhow in the place of occurrence. Rajkumar was my maternal uncle. Bonali was my aunt. I do not know where Ozoy Pegu put his signature in Exhibit 3 or 4. I do not know the contents of Exhibit 4. There's in Bengal. Enough Pegu.
PW 12, come to page 38.
It was teacher. No, the accused Limai Dole and Rajan Dole. I do not know the accused persons present in the dock. I know Rajkumar Dole. On 29th of August 2012, police informed us that Rajkumar Dole has been killed. The said information was sent to the Adjournment Police, Lingrai Muktik Police Station to Gormur Police Station. After getting the said information, I went to Gormur Police Station along with Gopinath Pegu and Ozoy Pegu. Thereafter, along with police, we all, I think, went to the house of Rajkumar Dole, Bonali. Thereafter, pushing the doors of the house, we entered into the house and found all the articles scattered inside the house. I also noticed Mekhala of Bonali Dole lying in the house. Then I, along with the police and the opposite person, went to the fishery of Rajkumar Dole. There, near the fishery, I noticed some blood stains and also found SIM card lying near the fishery. Police accordingly seized the SIM card. Subsequently, the police, after 8-10 days, arrested the accused person and informed about the same to us. After getting the said information, I, along with Ozoy Pegu, Gopinath Pegu, went to Government Pegu. There, I saw the accused persons in the locker.
Now come to the informant, page 42.
Police locker. No, he is the informant. Police locker. 28/8/2012, at about 12 noon, when I was in high school, my maternal uncle got information from police that my parents and the other brother went missing, but my uncle did not inform me the said incident. I told me that my parents are sick and took me to the Gormur police station. After going to the Gormur police station, I came to know that the parents are missing from the house. On the same day, I, along with police and my maternal uncle, went to my home and found the doors open. My mother, father, and brother all were missing from the home. I found Godrej Almira too, also open, and the materials scattered over there. All accused persons have killed my family members out of jealousy and killed them falsely, alleging them to be tiny. which my mother Bonali got a job in Anganwadi and due to the same, accused person out of jealousy claimed her to be, which will have my father and brother. Accused persons Babulal Dole, Rajen Dole, Anil Dole, so falsely alleging that my mother is a Daini, instigated the village people. This man was not there, my lord. He came subsequent to the incident. Yes. As my mother got appointment in Naganbadi, therefore, apostate person out of jealousy claimed.
Let's see the cross-examination that we have seen just now, 40, please, 44, the last line.
Yes. This is not a fact that the accused persons had not killed my parents and brother. It is not a fact that I have not written in the Azahar that the accused persons out of jealousy killed my parents, my mother and mother got the job in Anganwadi. This is not a fact that I have not stated before the police the name of the person who instigated the police claiming my mother to be dying. This is not a fact that I have proposed falsely. It's not a false fact that I'm studying since my childhood, staying in my maternal uncle's home. I am staying in my maternal uncle's home since class 9. This is not a fact that I do not know Nimai, Bokul, Razel, and Anil Dole. It's not a fact that I have stated before the police that Apel Dole, son of Mamung Dole in Narasika festival, after eating pork, died at his own house. I do not know what is the importance of this sentence. It's not a fact that I have written the names of the accused person as per direction of my maternal uncle. This is not a fact that Mamung Dole doubted my mother to be dying. It is not a fact that Nimai Dole, Bokul Dole, Rajan Dole, and Anil Dole does not know Mamang Dole. Rajan Dole, Anil, Nimai Dole, Anil Dole, and Bokul Dole are our relatives. This is not a fact that I stay in maternal uncle's home since my childhood. This is also a fact that I do not know how was the relation between the accused persons with my parents. It's not a fact that I was any sort of dispute regarding the land between my parents and the accused persons. Rajan Dole, Anil Dole, Nimai Dole, and Bakul Dole. It is not a fact. Laws false Azahar against the accused person and sending my parents. This is not a fact that I have not stated before the.
All right, we have read that. Now, 14, 15, and 16 are hostile.
They have been declared hostile.
Okay. Now come to 17 now.
Thing is the executive magistrate, Mila. He drew the sketch map on 4/11/2012, while I was working in the executive magistrate Madhuli, along with the police of Gambo police station, and the accused Ishapati went to the Lower Subansari Sapori in connection with something case. After going to the said place of occurrence, police officer prepared the sketch map.
All right, 18 is the informant.
18 is the IO.
Oh, sorry, informant, I'm so sorry, IO. Yes. Read this.
Yes, this will be little important, my lord, in the sense, on 29/8/2012, I was working at Gormur police station, Majuli, as officer in charge. On that day, Ranjit Patis and Brojan Misong gave.
This Ranjit Patel and Brojan Misong,
Yes.
were they examined at the trial?
Yes.
As PWs?
PW 5.
Huh?
They are 5 and 6.
PWs 5 and 6. Okay.
Gave verbal information that some village people, by apprehending Rajkumar Dole, Bonari Dole, and their son Moni Dole to be witch, took them to unknown place and killed them. After receiving the said information, I entered, and the same was entered by GD entry number 464 dated 29/8/2012. Exhibit 10 is the extract of the ED entry. In my signature, after getting the information, I informed about the said fact to the Superintendent of Police Jorhat. Thereafter, I, along with SI Nukul Das, SI Homen Singh, CRPF personnel and APBN staff went to the house of Rajkumar Dole. But after going there, search could not be made properly as it was late at night. From the village, I came to know that Rajkumar Dole also used to go to Borpeti Kanpur Ghat to catch fish. Therefore, I went to the aforesaid place, and after going there, I found some blood stains over there, which was tried removed by pouring water, but was not totally removed. I found one SIM card bearing number so-and-so, one Nokia battery, and one keypad of mobile phone in broken condition over there, and seized them in presence of witnesses, so-and-so, 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 exhibit 1 is so-and-so. I recorded the statement of the witnesses, and from the statement of the witness, I came to know that the accused person killed Rajkumar Dole, his wife, his son, at the aforesaid place, and by taking them near the Lohit River bank, and also came to know that after killing them, the dead body of the aforesaid persons were cut into pieces and were thrown away at Lohit River. The dead body of the aforesaid persons were duly searched by, but failed to find them out. On 29/8/2012, Santanu Dole, sort of, this is Rajkumar Dole, lost an FIR before Government Police Station, which was registered as Government Police Station, case number 20. On 30/9/2012, I again visited the house of Rajkumar Dole and searched the house of the deceased properly. After the search, I seized a piece of paper written by Rajkumar, which paper written by Bornali Dole on an exercise book written by Bornali, over which the name of Rajkumar Dole is written, and in the bottom, name of Bornali Dole is written. One Xerox copy of the agreement between Hemanto Dole and Kondarpur Hazarika from the house of the deceased person. Exhibit 2 is the scissor. Please, material exhibit 4, which I have seen. I prepared the sketch map in the house of the deceased. Rajkumar Dole, exhibit 14 is the sketch map. Thereafter, I recorded the statements of witnesses, namely Nilamani Pek, Ranjit, Kapir, Adjournment near the house of the deceased. On 30/8/2012, I arrested Kumbhir Patil, Supply Patil, and Barisa Patil. Following accused persons, namely Nimai Dole, Pulun Dole, Otul Dole, Janma Dole, Bakul Dole, Dinesh Morang, Bamun Dole, Raju Dole, were arrested by me at the police station. All the accused persons were brought by the village people, as after holding a village meeting, they found that all the aforesaid accused persons were responsible for killing the deceased persons. On 6/9/12, accused Otul Dole took us to Lohit Sapori, where, as per the information given by the aforesaid accused, they threw the dead body of the deceased persons after cutting them to pieces. On 6/9/12, after getting the information that the accused Otul Dole and Nimai Dole had hidden the house with which deceased persons were killed, I, along with them, went to their home, which is situated at Lohit Sapori, and from the house of Nimai Dole, a one dhow was recovered in presence of witnesses Ajoy Pegu, Gopinath Pegu, and Pawan Pegu. Exhibit 3 is the scissor. Another dhow was recovered and seized from the house of Otul Dole. There's a signal. In 13/9/12, witness Ajoy Pegu, Gopinath Pegu, and Pawan Pegu were brought before the magistrate to record the statement under section 164. On 4/11/12, accused Vishwapati brought me along with executive magistrate Damodar Varman near the bank of the Lohit River, where, as per the statement of the aforesaid accused, they cut the deceased person into places and threw them into Lohit River. The sketch map of the place, as shown by the accused Vishwapati, where the body of the deceased person were thrown after cutting into pieces, is drawn in my presence for witnesses. After completion of the investigation of the pending sufficient materials against the accused person of so I submitted search sheet and 13 is the search sheet. Witness Omar Kuli, without 14, stated before me that Rajkumar and Bonali Dole used some abusive language against some boys, due to which the aggrieved boys killed Rajan Dole, Bonali Dole, and their son Jitu Dole at night. The aforesaid witnesses stated before me the same, they came to know secretly that Nimai Dole, Bakul Dole, and Vishwapati are involved in the killing of the aforesaid person. He also stated before me that when the police interrogated the aforesaid person, they told that they killed Rajkumar Dole, Bonali Dole, and so after killing them, chopped them into pieces and threw them into the river. With the statement made by the affected person on the section 161 before me. Yosna Dole, PW 14, stated before me that the person in the lockup told her in missing language that they cut Bonali Dole, Rajkumar Dole, and Son Jitu Dole into pieces and threw them into Lohit River on suspecting them to be witch. The witness stated before me that the accused person did her, a person told her in missing language that cows, goats, and other animals used to run away by seeing Rajkumar Dole and Bonali Dole. The aforesaid witnesses also stated before me that the person told her that there was a dispute between Rajkumar Dole and the elder brother and his elder father. The aforesaid witness stated before me the person told to her that they killed the son of Rajkumar Dole, Bonali Dole, so that he does not become witness in the future. Exhibit 15 is the statement. The aforesaid witness under 161 status. Okunlo Bodwa 16, Kilo 16 stated before me that on 5/9/2012 from the evening bulletin, News Live and other sources, he came to know that government police arrested some persons in connection with witch hunting. Then he went to the police station and see the person sitting. The aforesaid witnesses stated that he arrived at the police station, he found police to interrogate Nimai, Pulin, Central Judges Center. Well, he stated that when police interrogated the person, they stated that they have killed Rajkumar Dole, Bonali Dole, and their son Jitu Dole, on which Sapori village. On 28/28/12, on suspicion of witchcraft, he stated that the aforesaid person stated in my presence, they cut the dead body. The aforesaid person into pieces and threw them in the river. The aforesaid witnesses stated before me, when personally interrogated, the aforesaid person told him they cut Bonali, Rajkumar Dole, and the son Dole into pieces and threw them into the river. The statement of the aforesaid witness is recorded in 164. Ross Miller. The written FIR was lost by Santanu Dole, son of the informant, closing FIR, stating that on suspicion against the accused person, he lost the FIR. No explanation of delay was explained in the FIR. I have not recorded the statement of the writer of the FIR Upan Pegu. Initially, verbal information regarding the incident was given by Bhajan Mishran and Ranjit Pati. This is not a fact. that I have not recorded the statement of the person with whom it appears from April Exhibit 6. That is photocopy of the agreement between deceased and members of the Missing Development Committee. Deceased Rajkumar Dole entered into agreement regarding fishery. I have not recorded statement of Kondopo Hazarika and Amanto Dole. The blood stain which was found near the Lohit River was not collected by me for chemical examination, as the same was not in a state to collect. Even if it is not sent.
All right, how has the court dealt with it? Why death sentence to one and sentence to all? It's all
That is very baffling to us, Lord. I don't know, but your lordship in the notarial. Your lordship he is the oldest one actually. What really transpired in the mind of the trial court regarding the sentence against Rajan Dole and the other accused persons, my lord, we really do not know. So,
Read para 134, page 290 of volume.
Thank you. After carefully scrutinizing each of the circumstances of the instant case, the circumstances as can be culled out from the evidence and materials on record and proved conclusively by the prosecution to bring home the offences with which the accused persons are charged are as follows. Number one, the villagers of Lohichapuri, Bordua suspected Rajkumar Dole, his wife Bonali Dole, and his son Jitu Dole of practicing witchcraft, which is the motive for committing the murder of the accused deceased persons. B, pursuant to the said belief, the accused persons formed an unlawful assembly and abducted Rajkumar Dole from the place from where he used to catch fish in Borgula, Konkur, That, towards Service River, tying his hands and feet, Bonali Dole, Jitu Dole, from their house with their intention to commit death. Now, where the landed trial court found the fact of tying with the rope. Now, these are imagination and nothing else. There is absolutely nothing. This person's Rajkumar Dole, his wife Bonali Dole, and their son Jitu Dole were last seen together. With regard to this also, there is absolutely no material, no evidence at all. In the company of the accused persons. After Rajkumar Dole, his wife Bonali Dole. And he is with regard to the extrajudicial confession in police custody.
No, where is the sentence, ma'am?
Sentence out of there. I think it has not been incorporated here in the either of the paper.
After the separate hearing, but where is it?
Oh, yeah, photo of that is paper book at nine. It's done.
Memo, it is there in the memo that there.
No reasoning.
That sentence.
This was its footnote recorded.
is 47 of April. Memo purpose. Memo. Again. Nine.
Distinctions. All have been convicted under 302. How is that possible?
My humble
All were
submission,
framed
no.
under 349, 302 by 149.
Where is the material?
That's something different. We are saying if there were material also.
Okay.
And then what is the distinction between the person who has been sentenced to death and the others? Nothing. Yes, Mr. Tell us about extrajudicial confession. Would it fall in that category?
No, my lord, I have point out just some points for argument, my lord, only 4-5 points, my lord. And because your lordship has read out the entire evidence, my lord. It is seen, my lord, from the entire evidence, it is seen. There are all discrepancies. Apart from discrepancies, my lord, this is the conviction is solely based on the, my lord.
Yes.
First of all, my lord, the points for arguments, that is, first of all, there was no eyewitness, my lord, that is explicit, my lord. The entire evidence case is based on circumstantial evidence. And as your lordship knows, my lord, the Honorable Apex Court has clearly said, my lord, that.
Yes, you have very ably summarized the argument.
Yes, madam. I have summarized the arguments. My lord. These are the only points, my lord, which your lordship may consider. And
Yes, Samas, where? You have a difficult task. Come here.
Lordship, being an officer of the court, my lord, and being a lordship, my duty is to place it before the court in a fair way, your lordship.
We
My
understand. But always remember that you are a prosecutor. You're not even a prosecutor. You're
I am officer of the court,
you're a
whatever is on
counsel to the
record.
state.
Yes,
So where you don't find the evidence to be in consonance with law,
my lord.
you can very well
I
say that.
should, I should.
We will not record that you will concede,
lord.
you have conceded, but then
My
you
lord.
can very well understand what is
Lordship.
there. There's nothing.
There's nothing apart from that, the leading, it was not in a proper manner, but they were in custody, my lord. While leading the recovery as regards two
If
weapons.
they were in custody leading to recovery, the recovery was from open space
That was from the open.
and the
space.
IO says that he recovered it from the house.
Two weapons were
That's
recovered.
right. And
yes.
so assuming that it is recovery,
My
so
lord.
much, 20 section 27
27.
applies, assuming everything.
My lord,
So 27 is only that part of the recovery.
my lord.
So how could it be linked to the
Exculpatory.
murder? Was it sent for forensic examination?
Nothing.
No stains of blood,
Nothing.
nothing of the kind.
Nothing.
This weapon is always there with people of missing community.
That's true, but it's not, has not been brought on record. It's normally available in the locality. I didn't find, but it is Lordship, copy down and all, my lord, one down, one copy down.
Even if
and
it is
one
not
chattel.
brought, even if it is not brought on record, how would a court take it into account?
Lordship,
Section
only on the
100
basis of.
Have the Evidence Act before you.
Yes.
Section 114 illustration, which
Yes, without-
illustration?
Yes,
Illustration G.
my lord.
Second, evidence.
114. EFG.
Yes, yes. I don't have. 100%.
G, my lord, 114.
No, that's not illustration. Let me.
Illustration, my lord.
Just a minute.
My lord.
Okay, it's not there. Court may presume existence of certain
facts.
So there's a common weapon. Not
Right.
corresponding to any one of the illustrations, but
Right.
it's a common weapon which could be found. And assuming that this recovery is acceptable as
Right,
an
no.
acceptable piece of evidence,
No.
what does it lead to?
Only on the basis of recovery.
No, what does it lead to here in this case? Nothing.
Nothing, except these two weapons that was,
And the statement of the deposition of the IU is that Majuli had 3 successive floods, dead body could not be found out. And this was in open space, it remained where it was. It was an open space, not hidden. Where was the question of leaving it? One. Number two, how can this be an extrajudicial confession? Because they were in the police lockup.
police custody.
And therefore the custody of the police was there even when they were taken to that fishery.
Yes,
So that is therefore
Gone.
definitely hit.
my lord.
So there, nothing remains. It's just a question of, and then these 2 persons who informed, they have said nothing about these persons.
Nothing, your lordship, absolutely nothing. I don't know how
The
come.
man must have, the husband, wife and the son may have been killed.
Yes,
Agreed.
my lord.
But then how about, how to fix the responsibility on them? And on top of it, without any distinction, look at the sentencing part 3 and 2 for all.
All.
Is that possible?
No.
Without 149?
No, may not.
And then where was the distinction that Rajan, the one was
Who has been sentenced to death.
was different?
And they could have exhibited this one, village meeting and all, my lord.
So what would I have done? Nothing. No investigation has been done. Tell you. Arguments heard. Reference literature from 66. Or adjournment.
But all the persons are in bail, even the person who has been convicted.
That is so.
Yes.
Everybody was on bail after,
Yes.
only that, after the conviction, bail was
Yes.
cancelled. This only tells the court that perhaps there was no evidence and therefore the court granted bail.
Yes.
All right. Thank you.
Okay.
Thank you, Mr. Das.
Okay.
Just a minute, the mic is not there. Mr. Das, you will not ask the legal services authority to pay you because you are senior advocate. Right, otherwise, had you not been designated senior, you would have asked the legal services authority to pay you.
Earlier also I did some, but I never paid them. Even at my each stage of my profession.
Good, very good. But here I would have asked the authority. We normally, young lawyers get paid.
Yes.
But not for you or MS Bhuyan. Both of you are senior advocates. Yeah.
Deeply obliged.
You can only expect a big thanks from the court.